this morning in the state of Ohio versus David Graves on two case numbers, the first being 24 CR 35 for a probation violation final hearing, the second being 25 CR 1342. On a prior day of court, the defendant did plead guilty to count 1, possession of cocaine, a felony of the 4th degree, and count 3, OVI, a misdemeanor of the 1st degree. Your Honor ordered a updated pre-sentence report on that case, which has been completed. We are here today for the purposes of sentencing.
He doesn't play to the PV, right? We need to do that first.
Correct, Your Honor. I think we just waived the probable cause. I don't think the
You're right.
final hearing's been officially waived.
We're going to address that first then. Case 24 CR 035, scheduled for a final hearing. Mr. Watts, what's the defendant's intention in that regard?
Thank you, Your Honor. May it please the court, after talking with my client, he is prepared to waive his final hearing and enter a plea of guilty to the violation, Your Honor.
Thank you. All right, Mr. Graves, in the first case, one that you've been on probation to the court for, you're charged with violating the conditions of your community control sanctions. Specifically, there's 3 alleged violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws, and it's alleged that on September 14th of this year, 2025, you were cited by the Whitcliffe Police Department for possession of a controlled substance, resisting arrest, open container, operating a vehicle that influenced of alcohol or drugs, and failure to control. That's the other case that we have before us. You're ultimately pled guilty to the possession of cocaine charge in an OVI. It's also alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on that day, that other incident, September 14th, you were in possession of controlled substances, and you ultimately pled guilty to the charges for that. There's also a supplement or an addendum that was filed alleging another Rule 8 violation, again, which prohibits you from using any controlled substance, and it's alleged that a urine sample you submitted on September 16th after you were arrested tested positive for cocaine and marijuana. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violation. Your lawyer has indicated he believes that's what you want to do, waive the final hearing and plead guilty. Is that correct?
Good morning. Yes, Your Honor.
Well, before I can accept your waiver of the hearing and your plea of guilty, I need to make sure you understand the potential consequences you face if you are found, in fact, to have violated the conditions of your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be 6 to 12 months in prison, and that could also be ordered to be served consecutive to any potential prison sentence that may get imposed for the new case, the other case that we are here for on sentencing. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
Plead guilty, Your Honor.
Very well, then, as to the allegation that you violated Rule, let me get that up here. That you violated Rule 1 by having been convicted of a new criminal offenses. What is your plea to that?
Guilty, Your Honor.
As the Rule 8 violation for being in possession of controlled substance, what is your plea to that?
Guilty, Your Honor.
And as to the Rule 8 violation set forth in the addendum for testing positive for marijuana and cocaine, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions in case 24 CR 035. We will now proceed to sentencing in that case as well as the sentencing in 25 CR 1342. We'll do both together. Any reason not to do that, Mr. Watson, or any reason not to proceed to sentencing in either of these cases?
No, Your Honor.
Then is there anything you'd like to say on behalf of your client in regards to both of these cases? Make your comments and obviously go for both cases.
Thank you, Your Honor. May it please the court. Yeah, I'm going to be brief. I know we had discussions in chambers. Mr. Graves, I believe, is a good person who's got a very serious problem. I know he's denied this problem to not only this court, to probation in the past. I think in discussions in chambers when probation brought up that it finally caught up to him, I actually thought that was very appropriate. I think it did. And unfortunately, how it caught up to him on this new case, the facts are obviously not good at all. He was behind the wheel of a vehicle, passed out. The vehicle was still in drive, on the road. And it took officers. They had to get into the car, put it in park. Took them a while to wake him up. Obviously, the cocaine was found as well. Your Honor, Mr. Graves has told me that he struggled with this for quite a long time. He knows this court previously gave him really 2 chances. They gave him a chance, and then I believe there was a probation violation on the old case already, and continued him on probation. So. And he was doing well there, I believe, for a while. Unfortunately, he fell off the wagon and hard. And Your Honor, we're here hand in hand. I know the court can do a lot today. Has a lot of discretion with regards to sentencing. I'm going to respectfully ask the court to consider a minimum sentence on both cases. Mr. Graves has expressed to me that he knows he's got some time ahead of him, but he plans on utilizing that time wisely. He wants to enter into some programs, do some AA. He wants to get out sober, and he wants to be sober. He doesn't want to be in this position ever again. He's expressed to me he's getting older. He's tired of this. He's tired of living his life like this, and I'm going to respectfully ask the court to take into account that he has accepted full responsibility here. He's very remorseful, and I'm hoping he'll get the help that he needs. Thank you, Your Honor.
Thank you. Mr. Graves, you have the right to address this court before you're sentenced in both of these cases. Is there anything you'd like to say in either or both cases at this time?
Dear Honorable Judge Collado, please accept this letter as I have written for mercy in regards to my crime I have committed, in which I am truly apologize and must first explain that I am reason to believe this is the root because of my actions and behaviors as a child growing up without a father figure. Just to say that I'm sorry, and I do have a problem, and I'm sorry that I came in front of you and everything. And I have my own business and everything. I'm trying to just ask for the minimum on my fines, minimum on my license and driving privileges. And I apologize, and I have a problem, and I want to use this time, like you said, that you give me and everything to help better myself, and got 8 kids, 7 grandkids, and all like that, and everything, Your Honor. And just asking for plead for the mercy on the courts, Your Honor. I got a long letter. I ain't gonna take up.
Sorry?
I said I have a long letter. I ain't gonna try to read. Take up a lot of time.
Well, you can say whatever you'd like to say. I'm not limiting you at all. It's up to you.
It's just above. And like I said, both my parents, they died of overdoses, and Mama was a prostitute. I was grown at 14, and I just made the wrong choices in life and all, and that's all. That's all, Your Honor. Just thank you for the mercy of the courts.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Contract for the state of Ohio.
Thank you, Your Honor. The state is recommending prison on both of these cases. By my review of the pre-sentence report, the defendant has 8 prior misdemeanor cases, 7 prior felony cases. He was on probation at the time that he committed this new offense. The facts of that new offense are very serious. There is nothing that I see that would recommend him that he is amenable to community control sanctions, so we would ask for prison on both cases. Thank you.
Thank you. This court has reviewed the pre-sentence report investigation that was done in both cases, the original PSR done in the 24 case, as well as the updated PSR that was just completed. Also a drug and alcohol evaluation that was completed in this newer case. I've read and considered that. I've considered the facts and circumstances of both cases, the nature of the cases involved. I've considered everything that's been said here today. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2929 11 of the revised code. As for the factors in 292912, in the older case, the 24 CR 035 case, I'm going to incorporate all the findings I made at the original sentencing hearing, first PV, with the additional finding at this time that the defendant has, again, failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. In fact, one of the violations was for actually committing a new crime, so recidivism actually occurred. In regards to the 25 CR case, the court notes in regards to the seriousness factors, just the very nature of the offense itself makes this much more serious than normal. Quite frankly, it's only not fine possession, I get it, but it's one of the worst ones I've seen. You're stopped at a red light, cars and drive, your foot on the brake for a long time. There's one woman that pulled up behind you, sat through a whole cycle, then she left to go pick up somebody, came back and you were still there. People were beeping their horn, knocking on windows, reaching in your car, and you had no idea, and you're driving a car in that condition. Putting everybody in the community and everybody in that area at risk. You want to harm yourself by using drugs or drinking, whatever, but when you put the other people at risk, that makes it much more serious, and that's what happened here. And the officer in this case opened the door, put the vehicle in park, removed the key, you didn't wake up. Yelled at you, began tapping you on the shoulder, shining his flashlight in your face, you didn't wake up. Shaking you back and forth, yelling at you, you didn't wake up. And you're driving a car in this condition with people, other citizens around. Nothing makes it less serious. As for recidivism factors, in the new case, the court finds the defendant was on community control sanctions to this court at the time that he committed this offense. He has failed to comply with previously imposed sanctions ordered by the courts, including this court. In fact, he was on probation to this court. He had violated just in July. And despite his history, despite the fact that I gave him a break when I first put him on probation, I continued him again with the first PV. And within, a month after getting out of jail, maybe 2, he did this. He's got a significant criminal history. He's been to prison 4 times before already. He's not responded favorably again to previously imposed sanctions. A drug abuse problem that relates to the offense, and he's adamantly denied he has a problem. Even though he's got a history of drug problems, tested positive for drugs, has drugs on him, he pointed, you're entitled to minimum sentence in mercy. You've been to prison 4 times. You're on probation when you did this. Why do you deserve mercy? Why do you deserve a minimum sentence? You don't. You're 49 years old, and you've been doing this your whole life. Wherefore, is the sentence of this court in case 24 CR 035. Going to serve a term in prison of 9 months. He's given credit for 181 days he's already served. Case 25 CR 1342 is the sentence of the court. Defendant serve a term in prison on count 1 of 15 months. That'll be served consecutive to the prison term imposed in 24 CR 035. Since it's consecutive, there's no credit on that case because he's getting all the credit on the first case. 181 days includes credit for both cases. Count 3 is a sentence of 180 days. It's concurrent to the sentence in count 1. Impose the minimum fine of $565 on count 3 in the new case. Both cases, I'm going to suspend the defendant's driver's license for 3 years. That's a concurrent suspension, though. 3 years in each case, but concurrent. The court's going to order defendant pay all costs incurred in both cases. Need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, this is for both cases, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. That's for both cases as well. 25 CR 1342, order the forfeiture of the contraband and instrumentalities as part of the specification count 1. I'll dismiss the balance of that indictment as well. Lastly, the court finds that consecutive service is necessary to protect the public from future crime and to punish the offender. These consecutive sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And the court finds that he committed the offense in the 25 CR 1342 case while he was on community control sanctions to this court in 24 CR 035. I think that covers everything. Ms. Contour, is there anything else for the record that I...
Your Honor, for the license suspension, does that begin on the date of the offense or today?
What was, has his license been suspended? If there's no ALS, then it starts today. If there's an administrative license suspension, he'll get credit for that, but...
I would have to look, Your Honor.
It would start today, to my understanding.
Okay.
Unless it's been suspended. The fact that he hasn't driven, that doesn't get credit for that.
Okay.
Mr. Watson, anything else?
Nothing further, Your Honor.
Thank you.
All rise.
5 minutes.
What?
5 minutes.
This is Shane Long from Burr Oak. He was placed on probation on April 9th of 2025 for 24 months on a charge of domestic assault or domestic violence with a deferral. His probation officer is Autumn Kiefer. She's filed a probation violation petition alleging that he has violated the probation by failing to abstain from the use of alcohol or drugs or to test on demand, alleging that he tested positive on November 13th November 9th. Also August 12th,
There's been several more days added.
and
to
several
that.
more days. I think he just threw, other than the alcohol part, was he complying with the terms of the probation?
He's attending the domestic violence group. We had an issue with financially, and he's back on the horse with that. He has attended 20 sessions out of 26. And he's working and attending treatment, but we have violated with the alcohol.
Which has been a struggle.
Correct.
Well, I'm pleased to hear that other part. I think it's in the thing. Mr. Long, I think we're gonna need to get a lawyer to help you with this. I've been in your business for a while. How old are you now?
32.
When did we start? When you were like 28, maybe?
I think first time I was ever in your courtroom when I was 21.
21.
Yeah.
We made a good go at sobriety court. We didn't get to the finish line. You're a decent guy, but you got a fundamental alcohol substance abuse disorder. We made some progress. Also, the things are then related to a domestic violence or domestic assault. This is a deferral. If you complete the deferral, the domestic violence charge could be taken off your record. You've done 20 of the 26 classes. You're still going to be on probation. Let's look at the original judgment, because I think I got 30 days of jail hanging over your head. 31. I could go several different ways here. The allegation is you violated your probation by continuing to test positive for alcohol. We let the one in August slide. Then we had all these in November. Autumn came to see me and said, what are we going to do with this? I said, well, set a probation violation hearing. I could just pull the pin and you could do Christmas and New Year's in jail, and then you wouldn't complete the class. We could continue the probation and you continue with the class, and we could do some sort of intermediate sanction. Like some weekends in jail, and then finally get to the finish line. But I don't have any more resources than I have in sobriety court. Takes all our heart and soul into that. And you were always polite, respectful. You just got a problem that you're struggling with. But I wasn't real keen on this domestic assault either, which also had alcohol connected to it. Are you working someplace?
Yes, sir. I work at O'Reilly's.
Oh, yeah, still?
Yeah.
Are you missing work right now?
No, I gotta go in. I typically work Thursdays through Sundays. Few Mondays, Tuesdays. Tonight I go in at 5, work 5 to close.
Or I'm gonna appoint an attorney. Set a PV hearing. Autumn, do you need to see him?
I don't, we just spoke yesterday on the phone.
Like I said, this could go several different ways. Now, you're still on probation. I want you to complete the domestic violence class. That's the most important component of the whole thing. That gives us some more latitude on what we're gonna do. by putting you in jail for 30 days. You're gonna lose your job. You're gonna have a domestic violence conviction on your record. You're gonna start from zero. And it's easy for me to say, hey, don't drink any alcohol. That's what I try to do when you're in sobriety court. If people could quit, they just would. So you have to work at it. Some point, either way, I'm going to get off your back. I'm going to discharge you successfully from probation, or I'm just going to put you in jail. And then when you get out of jail, you won't be on probation anymore. I'd rather do the first one than the last one. Anyway, you go out to the counter. We're going to appoint an attorney for you and set up a PV hearing. Devin Ackerson. All right, this is another probation violation arraignment. Both defendants were here. This is file number 25959SM. I drive past Mr. Ackerson's house on the way to work every day. He is charged with domestic assault. It was a 2-count charge of domestic assault, alleging that back in May, he assaulted Mackenzie Garcia by strangulation and then domestic assault. The charge of great bodily harm by strangulation was dismissed. The defendant pled to domestic assault with a deferral. His probation officer, Matt Huff, has proposed a probation violation. Same issue. I'll read the petition and I'll go back to the status report. The petition is alleged that you failed to abstain from the use of drugs or alcohol or submit to a test on demand. According to the status report, and this little snake is raising its head again, cocaine. You tested positive for cocaine on August 15th, August 27th, and October 27th. And then you were, quote, out of town on October 28th. Your struggle is cocaine. You can't afford cocaine. How is he doing in the domestic violence class?
Well, Your Honor, it's a bit complicated. We were waiting for him to get into his CDL class. He wants to be a truck driver, and that's a Monday through Friday. He has to get a schedule where they do that. So I wanted him to start in that so we could find the domestic violence class that would work to where he could also make it through there. And we didn't get him through 5 or 6 sessions in order to get ripped out, so that he could do the CDL classes, start all over again. So he has not begun those domestic violence classes as of today.
Yeah, this happened in May.
Well, that's when the offense took place, but he hasn't been on probation since May. It happened back in, I believe, August.
August 12th.
Yes.
He didn't get sentenced until, well, that day.
Yeah.
There's 30 days hung over your head. You're not going to get your CDL if you test positive for cocaine.
Yes, sir, I understand that.
That'll be a fool's errand. I see that you're recommending continued probation and some jail. I think he could benefit from an attorney as well.
Yeah, I think, I mean, based on the conversations I've had with Mr. Akerson, there's potential for, I think, for a resolution here. He knows that I want to continue to work with him. One thing that I would add is that we do have an updated testing record that I pulled yesterday. And so that does add a couple of more missed tests and then also another positive for cocaine on December 11th. So the recommendation would be slightly more, but I still want to work with him as long as he is willing to address the substance abuse problem. And I think he's got a really good opportunity for this case to go away as a deferral and for him to move forward with his life he wants to get his CDL and actually probably move in the direction that he would like to, then I'd like to keep it on the table because he's always reporting. He's always polite and courteous. I mean, kind of in the same vein of Mr. Long. I mean, that's what I'm dealing with, and that's the purpose of probation as it is. It's for reformation. So as long as he's willing to.
Well, one option is to just give him 31 days in jail or 93 days in jail and call it good. That isn't gonna do anything to address your cocaine addiction. You can't afford cocaine. There's a hole in daddy's arm where all the money goes. You have a new baby?
Right there, sir.
Well, that's all the reason you need right there is
Oh,
to
yeah,
get
I
off
agree.
of this hellbound train.
Yep. I do, may I add, I have a second interview for waste management tomorrow. So I
Okay.
am trying to get a way better job. And they said they'll pay for my training to become a CDL driver.
All right. I'm disappointed that we haven't started. Was he on the anger management or the full DV
Domestic
program?
violence. Yeah.
I mean, it
just-
was a felony strangulation case.
I've recently run into this problem before where I had to start somebody over after they were 8 sessions in because they couldn't swap groups. And it was a matter of choosing whether or not they were going to go unemployed or whether or not they were going to continue with domestic violence group. Community corrections in Kalamazoo indicated that if they have to take a time out, it's going to reset them back to number one. So that was my motivation. Whether that's right or wrong, I don't know. I suppose that's on me.
Well, that maybe there is no right answer. Each answer is as right as the other, but I am disappointed. And it's a 26-week program.
It is.
So the sooner but the underlying issue is the cocaine. It's very debilitating. B, it's money away from his family. And it messes with your cognition and your anger and your well-being. The original facts were not good. There was a gun involved, and that wasn't good. Your girlfriend pointed it at you. They ended up taking the guns away. Some video. Kicked her car. Slammed her against the house. Hit her head on the meter. Threw her to the ground. Grabbed her pants and ripped them down. She was pregnant. I remember this case. The plea was a gift. He's sort of complying. He reports. He hasn't started any treatment. He's continuing to use. Is he tested positive for anything else other than cocaine?
The initial test was very low levels of THC, but that's out of the system. So no is the answer you're looking for.
Are you still at the auto parts place in
No,
Kalamazoo?
sir.
So where are you now?
I work, I do snow plowing for total property in Three Rivers. That's the only job I can get. Can work with me and her schedule to watch the baby.
I don't like the thought of you being under the influence of cocaine while you're watching a baby. That ain't a good plan either. All right, I'm gonna appoint an attorney and set a PV hearing. You're gonna need to get it together. You're gonna end up in jail for a substantial period of time. We have a sense of what are our priorities, CDL class or DV class. He's gonna be on probation for 2 years at this rate. And if he's continuing to test positive or blow off the tests, and there is no Suboxone or antabuse or methadone for cocaine addiction. Ozempic and some of those new weight loss drugs may also affect cravings for controlled substance. But you're going to need to do something rather than just hold your breath and say, I'm not going to use any cocaine. What limited resources you have are getting spent on 8 balls, and whoever's selling it to you gets a special ring in hell for doing that to a man with a young baby. One way to make you quit is just give you 90 days in jail and let you detox. But Matt has some faith in the opportunity to be successful. I don't know how much cocaine was a factor in everything that went down in May. You certainly were very angry. But we'll get a lawyer to help you with this. His goal is to continue the probation rather than pull the pin. I guess we'll see how this plays out. You're still on probation. You're positive for cocaine as recently as December 11th. And I know it's easy for some guy in a black gown up here to say, don't use cocaine. But you need to do something. You need to get into AA. You need to get into NA. You need to get into Celebrate Recovery. You need to do something other than just say, I'm going to try not to use cocaine today. Then go out and spend your family's money on it. And this is important. If you're going to get a job in the trucking industry, you don't want a domestic violence conviction on your record. And this is a gift from the prosecutor to take this off. All right, enough. Proselytizing. You just need to get it together. You're going to end up in jail. So we'll get a lawyer. We'll set a PV hearing. We'll discuss what our options are. One option, as Matt had proposed, is some jail sanctions on weekends. And we'll see how we're doing. And I want to see if you're in some sort of support group. Like I said, cocaine is an old demon that was gone for a number of years and it's resurrected. Plus, they kept putting fentanyl in it. We had a number of people that OD'd thinking they were using cocaine. All right, you're good to go. I'll stop bitching at you. I'll see you when you have your lawyer here and we talk about this further.
Okay.
All right, you're good to
Thank
go.
you, Adam.
Thank you.
I don't know, maybe it's just me, but I think Judge Middleton could have bitched at him, as he put it, just a little bit more. I think he needs it, and he needs a lot of things. Yeah. Barbara put in the comments, wouldn't be surprised if he left the courtroom and met his dealer. I'm kind of on the same page. I don't think he's interested in fixing himself.
Here on the record today for the 28th Circuit Court here in Wexford County, and We're going to take up next the case of the people of the state of Michigan versus Stacy Edward Welch Jr. This is file number 25-14158 FH. Appearances, please.
Nate Carnes on behalf of the people. Robert Hartzell for Mr. Welch, who joins me at the table, Your Honor.
Thank you. That's all right. You may be seated. Thank you. Okay. We are here today for an initial pretrial conference in this case, and we held that in chambers, myself and counsel, a few minutes ago. And the counsel informed me that they had reached a pretrial agreement in this case, and therefore we're here to enter a plea. Mr. Carnes?
Your Honor, it's my understanding that the defendant will plead guilty to count 1, which is controlled substance delivery or manufacture of methamphetamine, MCL 333.7401 2BI.
Okay.
And the people will dismiss count 2, which is the exact same charge. It's also my understanding that the defendant has agreed to pay restitution based on the conduct alleged in both counts, and that restitution total is on the sheet that we turned in, migrated out of my file.
Well, let's see if it migrated into my hands.
I had it,
Looks like I've got
$1,750 to the Travers Narcotics Team South Office.
that was allegedly by money.
Yes, Your Honor, by money.
Thank you. Mr. Carnes, is that a
Gonna interrupt. Lindsay, $50 super chat. Thank you so much. That's incredibly generous of you. And again, I appreciate all the support you've given me over the last year. It means a lot. So thank you so much.
delivery, but it's actually a delivery?
Yes, my mistake, Your Honor.
That's okay. Thank you. All right, Mr. Welch, is that how you wish to handle this file?
Yes, Your Honor.
All right, please raise your right hand. You may remain seated. You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. All right, Mr. Welch, you are currently charged with felony information with 2 counts. Each count is a charge of delivery of the controlled substance methamphetamine. Each one of those are a felony, punishable by up to 20 years and or up to $25,000. I'm told that you're going to plead to one of them and the second one will be dismissed. If you enter a plea of guilty, you'll not have a trial of any kind. Does that make sense?
Yes, Your Honor.
By entering a plea of guilty, if I accept that plea, you'll be waiving certain rights. I'm holding up a piece of paper that at the bottom has your signature. At the top, it says advice of rights. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
And did you understand what you read?
Yes, sir.
All right. Additionally, if the plea is accepted, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to the court today on the record. Other than the agreement that Mr. Carnes and Mr. Hartel have told me about, have there been any other promises, threats, or inducements or force to get you to plead guilty?
Yes, Your Honor.
Are you therefore entering the plea of your own free choice?
Yes, Your Honor.
Okay. Now, when there is a conviction for a felony in a state court here in Michigan, there's what's called the Michigan Sentencing Guidelines that help the court determine what is a fair, reasonable, and proportionate sentence. I suspect Mr. Hartel has talked to you about those and tried to give you an idea or estimate as to what they would, how you would score and what the range would be. Is that correct?
Yes, Your Honor.
He's probably also talked to you about what he thinks might happen, just based upon his experience, not only in other courtrooms, but even more particularly here in this courtroom in front of me. Has he done that?
Yes, sir.
I want to highlight for you that whatever he's told you about the guidelines is just an estimate. That has to be prepared by the initial scoring is done by the Department of Corrections, and we'll talk about that in a little bit. But it's just an estimate. It's not a guarantee, because what's going to happen is when we come back to court for sentencing, if I accept the plea, we'll have those guidelines and each side has the right to challenge them. So somebody might, Mr. Carnes might think, well, the court guidelines should be higher. Mr. Hartel might say, well, they should be lower, but I'll make the decision. The key point is that no matter what those guidelines are, they are not mandatory. The court is allowed to go above them or even go below them. I just need to make sure you know that. So anything that he's told you is merely an estimate, as it is the judge alone that determines the sentence. Do you understand?
Yes, Your Honor.
Do you have any questions about what's going on today?
No, Your Honor.
Okay. So with knowing all that, do you still wish to enter the plea today that we talked about?
Yes, Your Honor.
As to count one, the delivery of methamphetamine, this one deals with the alleged date of October 16th of this year. How do you plead? Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. So turning your attention to, and while I know on the felony information here, there's a date range, but I can see that those date range, or that date range is really just based upon the two dates as alleged. On October 16th of 2025, out in Herring Township, which is on the north end of Cadillac here in Wexford County, what happened?
I sold methamphetamine to another person, Your Honor.
Okay, how did you make, how were the arrangements made for you to meet that other person?
They called and have me come down and meet them.
Okay.
And I agreed to it.
And where did you meet? Okay, so in the Home Depot parking lot?
Yes, Your Honor.
Okay, and when you met with that other person, where it was outside, is that correct?
Yes, Your Honor.
And when you met with that other person, did you deliver some amount of methamphetamine to that person?
Yes, Your Honor.
And while money isn't required for a delivery, did that person deliver you money in exchange?
Yes, Your Honor.
And then you left the area, is that correct?
Yes, Your Honor.
Now, you said you came down. Where'd you come from?
Saginaw.
All right, thank you. Do you remember how much that you delivered and for what it weighed or how much the amount was?
I believe so. It was around like 50 or 47 grams, I believe, Your Honor.
Okay, and then you received money for that. All right, thank you. Mr. Carnes, do you believe the defense provided a factual basis?
Yes, Your Honor.
Mr. Hartel, do you agree?
I do, Your Honor.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Hartel.
Or mine.
Mr. Carnes, you believe the court is in compliance with Michigan Rule 6.302?
Yes, Your Honor.
And Mr. Hartel.
Yes, Your Honor.
Thank you. There's one more term I just forgot that I need to go back and review before I accept the plea. You understand that there's an agreement that you were going to pay back an amount of restitution to the Travers Narcotics team, which is probably the one who conducted the sting. And that is a certain amount, and that amount of money is $1,750. Do you understand? And you agreed with that? And so it must have been over the two instances you collected that amount of money. Is that right? All right. Well, the court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense for count one. Therefore, the defendant is found guilty of count one. Count two will be dismissed at the time of sentencing. Sentencing will be done in about 4, maybe 5 weeks because of the holidays. We do sentencings every Monday morning in this courtroom. Whenever someone is convicted of a felony in a state court in Michigan, the Michigan Department of Corrections must prepare what's called a pre-sentence investigation report. That report is prepared and given to the court just prior to sentencing. The court uses it to help establish a sentence. That report will include a description of the offenses, the pretrial agreement, statements or information you make or provide while it's being prepared. It will also make a recommendation as to the sentence. It's strictly a recommendation, as they don't work for me and I don't work for them, so I determine the sentence. It will also include a scoring of the guidelines, and the guidelines, as I mentioned with you earlier, are not mandatory. It will also talk about any prior criminal history you have or don't have, how you performed on probation or bond in the past and this time. Anyways, there are 3 steps that involve you for the preparation of this report between now and coming back here for sentencing. First, when you leave the courtroom, you're gonna go downstairs to their office. If you take the elevator all the way down, step out, do a button hook to the right, you'll go down a slight ramp. There's a door straight ahead. Go through the door. Their offices are in that hallway. Because I think I've been told you're on a tether. If you've gone to the community corrections office, if you were standing right in front of the office and did an about face, you'd be facing their office. Now they're going to give you a packet of information that's going to ask a lot of questions, and you're going to fill it out and turn it back in. Second, they'll have an interview with you, and you have the right to have your counsel present during that interview. And number three, Mr. Hartel will get that report generally about 10 days, maybe 2 weeks before sentencing. And he's going to have to go over it with you, because each side has the right to come back to this court and request corrections or make objections to the contents or the scoring or whatever. So we need to make sure that it's complete and accurate before the court uses it to give a sentence. So that also means you need to maintain your communication and contact with Mr. Hartel, as he will also need to let you know when you need to get back to court next. All right. Any objection to Mr. Carnes to the continuation of bond?
No, Your Honor.
Your bond hereby continues. I know Mr. Hartel is going to make a motion, but I have to make that finding before he makes his motion next. So we're moving right along. Mr. Hartel, go right ahead, sir.
Thank you, Your Honor. I would ask the court to consider removing the GPS tether as a bond condition for what it is worth. My client is working with his father. They do Speedy X, if I understand correctly. It's a subcontractor for Amazon.
For FedEx, like it's just a third party Amazon. So
yeah, I understand.
So he does have family support as well. Supervision might be a stretch of the term, but he does have family supporting him. Family who is in the courtroom for support, his father and other family members. I would ask the court to give him that opportunity. The GPS does cost him quite a bit. I mean, that is one of the benefits of being on bond, obviously, but he is low income. I have done that type of work myself. A lot of the air quotes income goes back into resources to keep being able to do the job. So it would help him out quite a bit. Plus, if there's unexpected stops, community corrections, rightfully so, always wants to know what's going on, but sometimes you just need that extra bit of gas or whatever the case may be. So I would ask the court to consider that. I don't believe we've had any concerns with him on bond thus far. I don't think we would moving forward. I had quite a heart-to-heart, not only with him, but again, also with his family. And I do believe his family would, not that he would ever go off the tracks, but if he started to, they would put him right back on. I'll phrase it that way. I'm paraphrasing the fix. I don't want to say exactly what his dad said.
I got it. I have kids, so I know what I'd say to my kids, so.
Basically, yes.
All right, Mr. Carnes.
Thank you, Your Honor. I did look through the file. I don't see any bond violations. And I do recall we did a stipulation to allow him to travel to a different family member's house for Thanksgiving. There were no issues there. On the other hand, these are very serious charges, and I can understand the court wanting to keep all these conditions in place. He is also subject to random drug testing, which includes recreational marijuana. And again, we have no violations. I'll leave this completely up to you. Thank you.
Thank you. I love it when they say they'll leave it completely up to me. It is completely up to me. That's all right. All right. Mr. Welch, how old are you?
21.
Okay. There's someone out there or more people that were pulling your strings. And you fell victim, most likely, without me knowing exactly what's going on. And I don't mean to be guessing or stereotyping to be rude, but because you're young and you've got a family, right? Those are your children?
Sure. Well, that's my little brother, and then that's my youngest son.
Oh, okay. All right. All right. He's a cutie. All right. Odds are, because this happens on occasion up here in smaller towns in northern Michigan, and it's unfortunate, but I guarantee you there's a group of people who are pulling the strings, and here's what they do. They don't come up and deliver. because they're scared, and because they're not very bright, and because they use young people like you to do it because they think you're going to get 7411, HYTA status. They think that your likelihood of getting prison is pretty low, or jail is pretty low. We get the same young people that come out of Muskegon. They come up from Saginaw or Detroit. It's the same thing. Where are they helping you pay for your community corrections tether? It's okay. You're not going to answer the question. You know who they are. You're not going to answer and tell me who they are, their names. I got it. I'm not going to ask you that. You don't need to give it to me. But there's some people out there who are jerks who do not care about you and your family, because there's no way that you, most likely, made, from what I understand, 5 golf ball size amounts of meth. Right? You had about 5 ounces. All right. I used to sit over there when I did. The most I ever had as a prosecutor was about an ounce. Maybe, I think one case had about 1.5 ounces. It's now 3 times the amount. And it's because of these drug dealers that are using young people like you as scapegoats, because they do not care about you and your family. So when I think about this, I know you've got some financial obligations. You have family obligations. And don't blame the parents at all, right? Young people do stupid stuff. I'm sure Dad may have done something stupid once. I know I've done stupid things more than once. I'm sure Mr. Hartel has, and so has Mr. Carnes and everyone else in here. So I'm not trying to lecture you, but I'm sitting here and I'm wondering if there's a message that needs to be sent, so you can tell the other guys like you, because you and I know, without you even telling me, there you probably have friends or other people you know who are doing the same stupid stuff because of some group of idiots who are just drug dealers and only care about themselves. Because if they cared about you, your family, or anyone outside of themselves, you wouldn't be doing this. Or they would have done it. Who knows? They're cowards. So I also need to let you know your likelihood of getting a period of confinement is extremely high, right? I can tell that if you have no prior convictions, which I was told that you don't, at the very minimum, you're looking at a sentencing range of probably 12 to 20 months, which means I'd have to find substantial and compelling reasons to go below 12. And 12 would be in jail. That would get you 365 days with about 60 days of good conduct time. So right now, without knowing anything and without somebody arguing to me that I should give you and find substantial and compelling reasons to go below, your likelihood of going to jail for the 10 months is pretty high. I can tell you it's very high. I've never not sent somebody with a delivery charge to confinement. So I trust. So I know Mr. Hartel, and he's a good defense attorney. He's a good guy. He's very honest. He's probably told you that. So I'm going to tell you that I'm going to leave you on the tether, because underneath the court rules, I understand that the likelihood of conviction is obviously is done, and the likelihood of confinement is quite high. Because not only am I going to send the message to you, my likelihood is I need to send the message to all those other friends of yours out there that you know, that you were shaking your head about. They're going to get the message, don't. Now, I haven't made up my mind yet because I don't know anything about you. I'll say this. You look like a nice young man. You got a nice, some nice people back there. And I love that hat. By the way, I normally make everybody take their hats off, but that one can stay on. It's cute. It looks a little bit like an Ewok. I don't know if you know what Ewoks are because you're too young. Star Wars, never mind. I've just dated myself. So a lot of what I'm trying to say here is I don't know exactly what I'm going to do. How you do on bond, very, very, very important to me. So I'm going to leave you on the tether. I know it's expensive. We're going to see how you're doing. All right. How you do goes a long way with me on what I do for a sentence. You don't want, here's a tipping scale. 12 months is jail. With anything below 12 months is what I'm trying to say. So whether or not I give you 6 months or 12, or I put you on work release, or I do something else, that's jail where you get good conduct time. So at the most, it's 10 months. 1 day over, prison. Don't get good conduct time. Okay? Do you have a high school diploma?
Yes, Your Honor.
Fantastic. That's a great bonus for me. And you're working hard. I want to make sure you keep working. That goes a long way with me too. When I see people who don't work, don't have a diploma, it's real bad for them. So I'm going to leave you on this, but I want to see how well you're doing. I want to keep your nose clean. Okay? So I know I've talked about a lot of bad things and whatever. I'm not trying to be rude, but that's what you need to do. You need to go back. Dad, you might have some idea of who some of his friends are. Make sure they know these people are using them because they think he won't get any punishment. So that's what we're going to do. I'm going to leave you on it because you want me watching you. You want me seeing how well you do. That's really what's important. Plus, if I keep you on tether, odds are you aren't going to those people because they know I'm watching you. That's also another factor. All right, thank you very much. We'll see you here in about a month. Don't forget to go downstairs to the Department of Corrections and start that PSI paperwork. And take care of the kids. A good Christmas, okay? Learn from this. That's all that this is about, learning, sending messages, stuff like that, okay? I want to make sure that you never, ever get used by a bunch of jerks again. Right? The people behind you are much more important than them. And you can tell them, I generally keep my stuff on YouTube. You guys are not helping young people. Good luck. We'll see you in about a month. Thank you. We're adjourned.
All right, we are present in case 25 CR 508. This case is captioned State of Ohio versus Corey Hitchcock. This court received correspondence from Mr. Hitchcock contending that he wanted to file ineffective counsel due to multiple arguments and wanted to get a new lawyer. Court caused this correspondence to be filed and set the matter for a hearing. Mr. Hitchcock is here in court. He's with his attorneys, Ms. Nicole Novotny, as well as Mr. John Fatika. State of Ohio is represented by Mr. Nick Geigerich. All right, Mr. Hitchcock, you filed this request, so tell me why it is you think you deserve to have another lawyer. You got two of them right now.
Because they're not doing their job correctly.
Tell me what they're not doing.
So I've asked multiple times for a suppression hearing, and they keep denying me to file a suppression hearing when my rights have been violated on this case. My Fourth Amendment has been violated, and they think that there's no suppression hearing.
Is that it? This is your opportunity to put on there whatever you want to put on the record as to why you believe they're ineffective and you need a new lawyer.
Every time I have a conversation with Ms. Novotny, we ended up in an argument.
It's Novotny.
Novotny, my bad, I apologize. Every time we have a conversation, it either ends up in an argument or just feels like there's a lot of tension between me and her for some reason, and I don't think it's good for me to have her as a lawyer if she's representing me with the type of what is it? Like, I can't even say the words right. I don't feel like she's doing her job correctly with all the arguments and the tension between me and her.
Anything else?
No.
So the centers around the suppression issue that you contend there is?
Yes.
I know you, I read your motion, and you believe that your Fourth Amendment rights were violated during the traffic stop because the officer called you someone else's name while trying to arrest you, so you pulled away, making you resist arrest. That's the violation?
Yes.
All right, well, that's not a violation. It's not a Fourth Amendment violation. It's a fact you could present at a trial, perhaps, to explain maybe why you acted the way you acted, but it's not a constitutional violation of your Fourth Amendment rights. And a lawyer is not allowed to file frivolous motions. There has to be a basis, a legal, lawful basis for a motion. She or Mr. Fatika can get in trouble if they file motions that there's no lawful reason to support. So just because the client says, I want you to file a suppression motion, doesn't mean they have to jump at whatever you ask them to do. If there's no lawful or legal basis for them to file this, they're committing an ethical violation if they do it. And if your grounds are that you were called a wrong name, which made you jump away, and that's the reason you resisted arrest, that doesn't make any sense. It's a fact that could be presented as a defense, maybe at a trial, but it doesn't violate. I'm not sure how it violates it doesn't violate your rights in any way. And for them to file a motion making that argument would be an ethical violation on their part if they did that. Ms. Novotny, do you want to address this issue? I mean, Mr. Hitchcock raised this in a public filing, so you're permitted to address this issue and whatever else he alleged here today.
I mean, Your Honor, with regard to the arguments, we haven't had much of a productive conversation with that respect. I know we went for a jail visit on October 21st, and that was productive. Kind of went over everything in discovery with that respect and what we've seen. That's when that suppression issue was brought up, and we told him that it would be frivolous to file anything, so he's been informed of that. We also went to a jail visit on November 12th, which our visit was denied by Mr. Hitchcock. Ultimately, since then, our correspondence has been through letters, and numerous letters at that, just updating him on his case, which I have in front of me right now. So we've been in constant contact.
You've only met one time because he refused any other contact.
We met him on November 12th, sat down, told us they didn't want to see us anymore. So then it was denied, the visit was. So other than that, we've been corresponding.
There's this tension he talks about. There hasn't even been any meetings for there to be this tension.
We have been denied.
Well, Mr. Hitchcock, you have the right to have a lawyer appointed to represent you. You don't have a right to pick and choose who your lawyer is going to be. Both Mr. Fatika and Ms. Novotny are very good lawyers. Mr. Fatika's been doing this a very long time. Ms. Novotny's been doing this a long time as well. And they're very good at what they do. They don't need to, they're not required to, and they're not allowed to jump and do whatever it is you ask them to do if they're not allowed to do that, or if it's an ethical issue. And this is what you're requesting them to do will be a frivolous motion. Now, you may think because you were here before and you successfully had a motion to suppress that that's going to happen every time. That's not the way it works. There's no grounds that you're presenting me to indicate that they're not doing their job. They're doing their job the way they're supposed to do it. If you don't want to work with them, you don't want to meet with them, that's a choice you're making, and then they'll have to do the best they can do then without your input and your cooperation. I suggest that you meet with them, you work with them. They're here to represent you to the best of their abilities and to do what they can. But they can't do that if you're going to refuse to meet with them. You've met with them one time, and that was it. Go ahead.
I've met with them one time, and then the second time I didn't want to meet with them because of the attitude and the disrespect that they gave me.
When did they give you this attitude and disrespect?
The first time I seen them in jail.
An October date that she said? When you went over to the discovery and everything?
Barely even went over to discovery. I read the discovery briefly, and she's had the discovery since April. It says it on the paperwork. So therefore, how do I have any time to look at it? I've had a month max.
Well, you haven't been here. You've been in federal custody, haven't you?
Yeah.
So how's that supposed to work?
I was out on the streets before that.
Did you contact them and say, "Okay, I make an appointment. Can I come and see you guys?"
I've had a bond and everything. I've seen her before.
So did you make an appointment to meet with them when you were out on the streets?
No, she's never contacted
No.
me or
Did
called.
you? You're not listening to me. Did you make an appointment? Contact their office and say, "I'd like to come in and talk about my case with you"?
No.
Oh, okay.
I didn't have their phone number. I didn't know exactly who my.
Do you know what the internet is?
I'm not savvy with the internet.
You can't just go on the internet and look up, like, you're not savvy with the internet. You can't find the Lake County Public Defender's Office. You've been here before.
Yeah.
You've had them represent you, right?
But I didn't know who my public defender was.
You go to the office and you find out. You call them up on the phone and you find out.
I didn't know how to do that.
Then, what you want to say at this point, Mr. Hitchcock?
No.
All right, your request for a new lawyer is being denied at this point. This matter is set for a trial January 6th.
It's fine. I'll just buy a lawyer.
Sorry?
Sit down. I am.
What'd you say?
I'll just buy a lawyer. It's fine.
You just what?
So I'll purchase a lawyer. That's fine.
You're going to purchase a lawyer?
Yes.
Look at their piece of property?
No, I have family members that.
All right, well, tell whoever it is that you purchase that they're going to trial on January 6th.
Of course.
It won't be continued. So that is 2.5 weeks, 3 weeks from now, Tuesday. We need to know by this coming Tuesday whether you're going to accept the state's offer or not. So your purchase lawyer will have to contact this court by December 23rd to say whether it's going to be a trial or whether it's going to be a plea. Is there an offer that's been made in this case?
I do believe I gave him count one, Your Honor. Yes.
Give me a second.
And the other thing is, Your Honor, I'll be out of the office from the 23rd on. So it's, as far as I'm concerned, I'm just going to subpoena, I'm getting ready for trial.
Well, probably should. So the state made an offer to you to plead to count one, they'll dismiss count two. We need to know by next Tuesday whether that's being accepted. So if you have a new lawyer by then, they need to let us know that. If you don't, you need to let Ms. Novotny or Mr. Fatika know whether you want to accept that offer or not. Otherwise, we'll be going to trial on the 6th. Yes?
What is the offer exactly?
The offer is plea to count one, aggravated possession of drugs, a felony of the first degree with the MDO specification.
And what's the mandatory time for all that?
What is that for that?
11
years. So, I mean, we'll get off here. If you want to sit around here at this point, at least and talk with them, you can, you should. You should work with them. They're good lawyers, and they're here for your best interest, whether you believe it or not. If you want a few moments to speak with them, we'll leave and turn off everything. I'm happy to do that.
I would like that.
And Your Honor, in the defense of Mr. John and Ms. Novotny, if the court would like me to proffer why this all occurred, I will do that.
Why? What all occurred? I don't want you to do it. When you say why?
Where he wasn't responding to them and all that, there's other factors that go into that.
I don't think that's necessary.
Because I can't stand here and listen to him malign Mr. Fatika and Ms. Novotny.
The obligation's on him just as much to reach out if he wants to talk with his lawyers. He chose not to do that at all. So we don't need to do that, but I appreciate that. But I'm gonna get off the bench. The prosecutor's gonna leave. We'll turn off the mics and everything, and you can. In fact, why don't you go we'll let you go in the jury room. It's more private in there. There's gonna be a deputy in there, but let's just stand off to the side, and you can talk with them.
Thank you.
All right. Anything else for the record?
Nothing more.
All right. Thank you.
Okie dokie. So he's going to buy a lawyer, or that's what he implied that he might to do. So I went out to Amazon. There is a definite gap in the market. I cannot find a lawyer for sale on Amazon, and Amazon sells everything. So I'm thinking, I want to do a bunch of new merch for 2026, and I'm thinking we need a lawyer you can buy. So I'm going to have to work on that because, the businessman in me sees a gap in the market. You have somebody like this that wants to go buy a lawyer, and it doesn't seem like you can get one off the shelf. So I'm going to see if there's something I can do about that. So stay tuned. Let's go to Texas, Judge Stevens.
Four cases? Or five?
Five.
Five. All right. Mr. Curtis, as you know, you're charged with serious offenses involving child pornography. There's a first-degree felony, which carries with it up to life imprisonment in 2459. Then there's a state jail felony, invasive visual recording in 460, which carries with it up to 2 years in the state jail. Then we have another state jail felony of invasive visual recording in 461. And an additional illegal possession of promotion of lewd visual material depicting children, a state jail felony in 2462, and finally in 2463, a second-degree felony of burglary of a habitation. So that carries with it up to 20 years in prison. So it's total, you're exposed to 26 years in prison plus life on all of these, adding them up together. All right, what are we going to do?
Judge, I know we're getting up there in age a little bit.
Yeah.
Miss
Yeah,
Moore
year.
recently
Yesterday, I think.
inherited these cases upon her return to the VA's office. Mr. Davis and I would like some time to speak with her before we formally put these on file document.
Yeah, 4 weeks. And that's it, right?
Yes, sir.
Probably.
And okay. And we're going to go to trial. It's going to be the 2459, the first degree felony.
We know that. That's why
We'll take that
I'm
first.
asking before we get that.
All right, and we'll go one after another after another. Get a resetting.
Thank you.
Okay. Well,
he's present.
Well, 557. That's another old one. This is another old one.
I know.
So, today, what are we gonna do?
I suppose the court will put it on the trial docket if that's necessary. I've got an issue in another county that's unrelated to this. Frankly, doesn't have much bearing on the outcome of this case at all, but
I think there's a deferred offer written down. I don't know what the status of that is, but it's not going to change right now. If you want to just have a little time to work on the other county for a minute. That way we don't have to place it on the trial docket. Just give them 2 weeks.
This case will get resolved at a trial this month. I need the other county's issue to have an answer before.
Time-wise, what do you ask?
6 weeks.
How much?
6 weeks.
I'm gonna do you 4.
Okay.
Okay, thanks. Armando Alvera, is that a hearing?
Yes, sir.
That's a hearing too.
What about Andrew Barnett?
He's present, yeah.
It's all right there in the.
So,
Yeah.
Yeah, you don't have to unless you want to.
I don't.
I don't.
More.
Right there. Yeah. Sorry.
Product official.
Okay.
We were waiting for me to find the complaint. I found him in Louisiana and he's wanting this prosecuted fully, so it's.
Okay. Third degree felony up to 10 years in prison.
Yes, sir.
Right?
Yes, Judge.
I'll get a lot of these.
Yes, sir.
This,
We've tried a bunch of them.
sir.
We've tried several of them. So,
Okay. Then it will be set for trial. And then I'll verify.
This one we already tried jury given probation. I think he's asking for removal of something that was on the bond, but it's not on his probation order.
I filed. There's a misdemeanor DWI that was the companion case to the case that we tried in early October.
This is the case out of command.
Yes.
After we received probation from the jury.
Yes, Judge. After that happened, 2 or 3 weeks later, we resolved the misdemeanor DWI for time in the county jail. My belief is that once that judgment was entered, the bond conditions on the misdemeanor are extinguished. So as a condition of his bond on the misdemeanor DWI and at the interlock, he's had it in his truck for 4 years. My position is that the judgment is what should be sufficient to take to Smart Start or any other interlock company to say, I now can have this removed. He's not on probation. It's not a condition of his probation.
Why can't I?
You can, I suppose, as a condition of the felony probation. I obviously would ask the court not to. He's had it for.
Well, okay. What are we talking about now? We're talking about auto ignition interlock?
Yes. It was a condition of bond in the misdemeanor case.
Okay.
I filed a motion in county court to have it removed because Smart Start? Yes. Smart Start has found insufficient the judgment to take the interlock out of his truck. He is perfectly within the rules to have that removed. It's no longer a condition of his bond. He's not on bond.
Judge, I don't know if we have anything in this court to do with that on the misdemeanor DWI. That may be between the judge there.
Okay, he does.
It declines.
I've got an order in August signed ordering him to have an auto ignition interlock system as a condition of community supervision in this case.
On what date, Judge?
On August 27th. Which would be normally customary in something like this. I normally do that. And that was in August. He hadn't been doing that?
He has been.
Yes.
Oh, okay.
They're trying to get it removed.
The interlock has been in his truck since December 20 something of 2021.
Okay. For a different reason.
As a condition
the
of
auto
bond.
ignition interlock is here for this reason, because it's a condition of probation from the jury decision.
Which I overlooked this, otherwise I would have addressed it differently.
But I signed, I can't remember actually doing that, but that would be normal and customary. That's what I do in this type of offense.
Wouldn't it be, Your Honor, more normal and customary in a case that's actually a DWI indictment and not? I know this was an alcohol-related case. I'm not pretending it wasn't. That's why we tried it. But it was an accident involving injury, not DWI.
It doesn't matter. It was part of the circumstances of the cause of the event.
Understand. Our position, I won't re-argue the bond thing. He's had it for 4 years. he's done well. I know the court and the state's position is probably, yeah, he's been in there for 4 years. I get that, but at some point, there must be some level of relief now that the case has been resolved. And I think that the jury's verdict, based on everything that they heard, carries some weight.
About, of what? Of what as far as this condition is concerned? Why does it carry weight for my decision on a condition of probation, which involved a circumstance involving alcohol?
I think if the jury
That's what
believed that those two things were that related, we wouldn't be here. He would have gotten 10 years in prison.
No, I'm sorry. Well, number one, you bring some jurors up here and testify to that, number one. But number two, when it becomes my supervision, it's my domain, not theirs. But I don't remember them saying that or reflecting that. I remember this situation. But this, whenever there's an involvement of alcohol or drugs, then we do something to prevent someone from doing something a second time involving a 4,000-pound missile. Everybody has to act responsibly. Lives are dependent upon it. So I'm going to stand by right now that order, and it's going to stay that way. And what does it cost you?
Like $200 was.
I'm sorry, sir?
$200 a month.
Where are you employed? How are you employed?
I'm self-employed.
Okay. And at the end of the day, this is what I'm going to conclude with, because I think this is what carries the day on this issue. Mr. Alvera, the consequences of this condition to you and the difficulty that you have to deal with it, and it's the inconvenience of it and the cost of it is far less than the family that lost their loved one forever because you fled while they died at the scene. That's what I balance. Can you understand?
Yes, sir.
It's not a close call. You can figure out how to bring them back to life. I'll drop this condition. I'll probably relieve you of this condition sooner than later. But right now, it hadn't been but a few months.
I don't mean to be argumentative, Judge, but
whatever. What was my order? I'm talking about my order on this.
I understand.
Okay.
Want to be clear that he had it in his truck while the case.
I'm just talking about my order
Understood.
on this probation. Yeah. Okay. What else?
The misdemeanor case was resolved. The court will also recall that it ordered upfront jail time after the jury's verdict. Armando.
Was it 180 days, I guess? That's what. Stand by.
I think it was 180.
Yeah.
It was all of it.
Hold on.
College.
And here's the judgment on this. What's the 180 days jail time on that?
It's gonna be in a separate. Be.
You copy this? It's not on there, Judge. That's just the interlock. That's yours. That came out of the court's file.
Oh, okay.
That's all I want to make sure it got back for.
Thank you.
That was assessed at sentencing?
Yes.
Have you been going to jail?
Yes.
I know I remember orally ordering that. I'm not seeing it on the written order. Which is more of a memorial, it's a memorialization.
Right.
But the court made its order, but it's not in the written order.
But if it's dictated, the dictated order.
Yeah, I mean, I made it.
I know the court told him to go because I told him to go and I wouldn't.
Yeah, I know.
Otherwise.
I made the statement and it was an order. It was an oral order, but we normally memorialize those for posterity.
Yeah, I'm looking, Judge, I have the order where it shows that he could start weekends.
I think we waited a couple weeks after the verdict to get some affairs in order.
Yeah, I have the order where it said he could start weekend jail time.
Nonetheless, it was ordered. Sure. And it's somewhere in the 5,000 case load paperwork that we're having to deal with in this court.
Overstood.
So go ahead. What do you?
I'm asking the court to suspend the remainder of that time. He's done it faithfully.
How many days has he been credited with, do you know?
It's done.
September 19th.
You're doing every weekend?
Yes, sir.
How many days are you getting credit? Is it 3?
My
You come in on Friday?
Yes, sir.
And then they release you on Sunday?
Yes, sir.
You should be getting 3.
Yes,
He's done.
I thought each day, I thought when he shows up, they give him that credit for that day. And then the second day, and then the third day, even if it's partial, he gets 3 days.
That's correct.
They stopped it.
Yeah.
They only give them 2 now.
Did you know?
They
Kendall?
give them 2.
Yeah, they did stop it, Judge.
They're just giving it per hour. You have to have 24 hours.
Yes. They're only doing 2 days now. Give them 2 days credit.
All right.
Which
I don't know how much. Well, do we know how to credit his jail time? We can do that. We can find out where the number is.
Yeah.
Did we find something?
It might be, I reprinted the file, Judge, but I didn't have time to go pull it from the vault. So it might be in an order that's not scanned in our file that's in the vault. I just, by the time we got out of court yesterday, I didn't have time to go pull it, so.
Because I've got the community supervision order. I've got
So I reprinted everything that was
the
scanned.
supplemental order signed on the same day of additional terms of probation, which is
But it just may be in an order that's not.
auto
scanned.
ignition, complete MRT, moral reclamation therapy, and complete defensive driving as directed. But there's no. But I know I orally ordered there it is, serve a term of 180 days in the county jail. It's in this order.
Okay.
Over the top.
Okay.
But if you can tell me how much credit, and I will say this, this isn't the timing of such a thing, such a request is not ripe for me at the Christmas holiday season. I'm not gonna stop that condition. Since this is the most vulnerable time for people on the roadway. This is where most deaths occur during the holiday season. And,
Has he been doing weekends, Paul?
Yes.
and
Cause it,
so I can revisit this at another time, but not now. I'm not going to grant it right now.
They're not showing it?
well, it doesn't show that he ever booked out.
He's right here.
I know, but that's what I'm saying, I'll have to call Michelle.
Following for escape.
See, that's how they do it now. They don't do it, they don't book them out until actually the last day. But if you look at the screen that shows the inner something screen, it'll show like the exact days.
Well, does it have a running total? That's what we're looking for. Where's the data that shows a running total?
Well,
What's
What?
his time?
You're showing it's still totaling today, too.
Yeah.
Section.
One more issue, Judge, from the court.
Which question?
Because when I go to jailings, it's 91, which is not accurate.
These phones, intern. But they have broken up in increments.
Okay, so
Is it at the top?
It should be at the very top.
he started in August.
Are you gonna hear?
Yes. Or September to September.
I mean-
Right, because August was the judgment.
Same thing we. Sure.
Yeah, what's it called?
See, this would all been afforded that you're.
September, October, November.
Got what I asked for, more issues.
See, my one is so simple.
I don't think I have
Done it
permissions
three.
for that.
Okay. So the thing.
That would been, I still have this stuff.
I mean, he can't have 30 to 40 days if he's only doing 2 days.
That's story. Okay.
He's only credit to 2 days.
I know.
He can only, he's only got 30 or 40 days credit.
Yeah, I don't have permissions for whatever screen breaks it down, Judge. I'll have to if I get permissions for that. So I don't have an accurate.
During this time, at this time for the circumstances of this case, I'm not granting the relief right now.
Would the court consider modifying his weekend curfew or his ability to operate a motor vehicle on the weekend in lieu of fully suspending jail time? It's about to be crawfish season. He's about to move to working 8 days a week. And the weekend time.
Okay.
Is valuable.
What is the?
What?
Okay, I have be inside your home 10 p.m. to 6 a.m. That's the only curfew.
I'm sorry.
It says be inside your home every day, 10 p.m. to 6 a.m. That's the only curfew. What else is there? What do you? I don't see anything.
The way to get some relief. That's
Well,
all it is.
What are you asking for? Because I'm not keeping him in home except during for curfew. I mean, he can out and about as long as he has an auto ignition.
And with curfew, usually they'll allow you to work if you're working. Isn't it true? Probation allow you to work if you've got a curfew, if you work past that curfew, as long as you let them know.
The reason that I'm asking is because the weekend jail time is going to affect his ability to work. That's why I'm asking for the relief.
Okay, but I'm sorry, but he's going to continue to do weekend jail time for the reasons I stated. It was a fatality and a death, and that may infringe upon his work opportunities, but it's pale in comparison to what happened here and the loss of life. What's the value of that? There is no value to it. It has no quantifiable because it's forever, and the loss of life is the most precious thing that we have.
Okay.
When we lose it,
Yeah.
there isn't anything that is close to value that compares to it. You have your life. You've got some conditions which may be difficult or inconvenient, but you've got a life to share and enjoy with your family and friends. This deceased person doesn't, and their family was lost. And at this time of the year, I'm sure they think, well, that's what people think about. It's their loved ones here and gone. So no, I'm not going to grant the relief at this time for this situation.
We can certainly reserve our right to revisit it later. Judge. Okay.
Okay. You may. Yes, sir. All right. Who else? Was this? Is that it?
Yes.
Okay.
We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Michael Winquist in person in custody with counsel Eugene Harrington. We're set today in this matter for the sentencing portion of this case. Mr. Winquist pled guilty on September 8th, 2025 to count 2, 3, or excuse me. Yes, to count 1 amended to second reckless injury with a firearm as a domestic enhancer, count 2, 3, 6, 7, and 8. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. And in my review and in my knowledge of the facts of the case as they specifically relate to Mr. Winquist, the court did not see any mistakes or need for corrections. But again, the parties, the council have better information with the specifics. Mr. Schmidt, did you receive and review the pre-sentence investigation report?
I've received it. I've reviewed it. I have no corrections.
Mr. Harrington.
I received it or reviewed it. I went through the document with Mr. Winquist. We disagree with some of the characterizations, but we don't disagree with the facts in large part.
All right, thank you. Mr. Winquist, you agree with what your counsel has just stated?
Yes, Your Honor.
Okay. All right, before we move to arguments from the attorneys, I'm going to have the victim impact statements. Ms. Bauer, please let me know the first individual who will be speaking.
Pam?
What is Pam's last name?
Brew.
Can you spell that, please?
Breuhl.
All right.
Oops, sorry.
And for the record, please state your relation to this case.
My relationship to Christina is her mother.
All right, you may begin.
Well, I mean, really, what can I say? I mean, Christina has been shot. She's had to go to the doctor several times during the month. I think it was, don't quote me on this, but I think it was like 34 times out of 30 days that she was at the doctor. It's caused a huge hardship within our family. I mean, really, what can you say? My daughter's been shot. Yeah, she may look normal, but she's not normal inside. Her cognitive ability is not there. And then you expect her to live a life, and the rest of us to live that life as well. I mean, it is what it is. I mean, the doctor's reports and everything has been there, has showed everything. She's not okay. And, you know, let's get back to where, you know, the very beginning of really what happened and what's gone on. And that's what I expect the council to do. Thank you.
Thank you.
Deb is next.
What is your last name?
Kelly, Kelly.
All right, and please state your relation to this case, and it looks like you are going to read something.
These are just my notes.
Okay,
For the
and
most
I'm
part.
fine with that. If you read something, just please make sure to read it slowly so the court reporter can take it all down, okay?
I will do that.
All right,
Thank you.
thank you.
Thank you, Your Honor.
I didn't get her last name.
Kelly, Kelley.
Kelley.
Oh, Y, sorry, I wrote
That's
EY.
okay.
I apologize.
That's okay. I am a friend of the family, also Christina's advocate. I have been here since March of 24, or sorry, March of 25 is when I was asked to kind of step in and help with the family. Christina did not have the ability to schedule appointments, drive anywhere. So they needed somebody to kind of coordinate all of this, and I stepped in and took that role. During the time that I've gotten to know Christina, I just love the girl. She's just a sweetheart, but I didn't know her before. So all I can say is how I can perceive her now, but she's had so many doctor visits. We had to establish primary care because she had to leave her home in Cambridge, which she lost because she didn't have any employment. So she left her home in Grantsburg and moved to Cambridge so that her son could stay with her sister. She's been to neurology. She has a TBI. She has seizures almost weekly. She had a brain bleed, which resulted in having a coil implanted. We've had psychological testing, behavioral psych testing. She's been determined that she has moderate to severe memory issues and moderate neurocognitive disorders secondary to the TBI. She's been to cardiology. She's had at least 4 cosmetic surgeries to repair the injury to the scalp. She has 2 more coming. The surgeon did make a comment that it was like putting Humpty Dumpty back together again. So that was kind of interesting because it was such a mess. The orthopedic, she has injuries to her neck and her lower back. She is now using a cane and a walker, depending on where she is. She's supposed to have a sleep study done, but she's got some trauma with that for fear of being away and being around others. She has biweekly therapy sessions for trauma, PTSD, anxiety, depression, sleep issues. Excuse me, she has 90% hearing loss, both hearing aids in both ears, and all of this is a result of the injury on May 31st. She had left Grantsburg, the place that she knew as home. She lived with her sister for a while, and her son lived with her other sister. They weren't able to be together. The home that she lost was the home that she had with her prior husband, who has since passed away. So this home meant a lot to Christina and the boys, and it's now gone. And to clean up the house, because of the damage that was done, just the biohazard cleanup alone was $28,000. That does not include repairing of the subfloor, new carpet, new sheetrock, new appliances, new flooring. That's above and beyond. Her home in Grantsburg had been robbed many times to the tune of $18,000 plus, and those charges are still pending. And that's because she was unable to be at the home. Because of the result in the loss of the home, she's incurred about $20,000 in attorney's fees, which we're not sure how those are going to get paid. Right now, her only source of income is working very part-time, and her deceased husband has a small pension. Otherwise, that is her only source of income. We've applied for Social Security disability. We've initially been denied, but we are in the process of appealing for that. She's been subject to some online harassment by the defendant's ex-wife, and also his aunt apparently made an appointment. We want to make sure that this is known to him too, and his mother. His aunt made an appointment to see Christina. She is a cosmetologist at the salon. Was very intrusive in a lot of the questions that were asked. Christina was just being very polite and very, didn't give a whole lot of information. And then as she was leaving, she turned to Christina and said, "By the way, I'm Mike's aunt," and left. That caused some serious trauma for her. No matter what happens, Mr. Winquist will be able to leave at one point and lead a relatively normal life. Christina's life has been irrevocably changed. There will be no living normal for her. She has PTSD. She has flashbacks. She has blackouts. She is fearful of being in public, or especially being around men. Her and Donovan they're doing good based on the circumstances here, but life is not normal. They're doing good, meaning that they're here physically, as to what could have happened. That's all I have for now, and thank you for your time. I appreciate that.
Thank you, Ms. Kelly. Donovan, what, you can either tell me your last name or you can give me an initial.
Check.
Can you-
CZECH.
Okay. And you are the victim's son?
Yes.
All right. What would you like me to know? And I'm going to say you sound a little spoken, which is okay, but can you speak into the microphone and talk as loudly as you can and try and enunciate your words so I can hear them and so my court reporter can hear them?
Yes.
Okay.
So like, I don't really understand why it's not child endangerment is added to it. Because if the gun was not jammed, I know for sure he would have came after me because I was still in the house. I was behind like one of these walls right here. I was behind one of those.
And you're pointing to the jury box?
Well, like,
So it was that high?
no. So our stairs are on the other side, and he was over here in our house by the fridge. He could have easily, because there's no basement door to get out. So he could have easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. For the whole night, I didn't even know she was alive or dead because they didn't give any information. And then I had to stay away from my mom 3 months. 3 months. She had to heal. And I was living at my aunt at the time. We saw her for the first couple days, saw her breathing tube down her mouth. She could not talk for the rest of the week after she got shot. And then the next week, she was a little bit better. And then we saw her heal. But then she said, "I can't hear you, Donovan. You need to speak up." And then they're thinking about that she won't even remember me ever again. But that was proven that she could remember me. It was just a hard time. We're struggling to pay bills, all because of this happened. And then we get robbed like a couple nights after. And then, I don't know. And then we expect him to come back to the same community, live his life, a normal life. He can do whatever he wants as soon as he gets out. But me and my mom struggle to do stuff that we want to do because it depends how her legs feel, depends how she feels that day. And sometimes she gets so scared at night that she comes in my room, makes sure I'm still there, and checks on me. That's how bad it is. That's how bad her PTSD is. I'm seeing weekly therapy with my PTSD because whenever she has a man over, I have to tense up or I have to get involved. It's just we can't live our life normal again. We can't trust any man that's in our house because we don't know what they're gonna do. And yeah.
Thank you, Donovan.
Yeah.
All right, and you can either state your name for the record, or you can just use your initials.
Christina Fickbaum.
All right. And I'm going to say the same thing to Donovan. Please speak into the microphone just so I can make sure that I hear everything and my court reporter can too, okay?
Okay.
And if at any time you need me to turn up the system so you can hear better, if you're missing something, just raise your hand and then I'll know that I need to turn up our audio system, okay?
Okay.
You may start whenever.
You know, it took me a long time to decide what I was gonna say, what I wasn't gonna say, because
And I'm so sorry to interrupt, but can you just, I know that this is, that you're in court and your anxiety is probably really high, but can you just speak a little slower too?
sure. I struggle with it just for the simple fact that, you know, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, you know, one of the big things that, you know, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that. You know, like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. You know, I always tell people it's like in reference of when you blow out candles on birthday cake, that's how fast my life was gone. He didn't kill me, but my life left. And, you know, the other thing too that's pretty hard is that he could have very well taken another parent from my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess, Debbie, can you?
Yeah. I want to get one thing that I know she wants me to.
Is that all you would like to say today?
She's gonna have Debbie finish for her.
Right. Okay, and that's totally appropriate and fine. If you are going to read something, please read it slowly.
I will.
Thank you.
Okay. The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There is one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen, I wasn't chosen, I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. You broke things in me you had no right to touch. I kept trying to heal with the same hands that hurt me. You You didn't walk beside me, you dragged me. You weren't building a future, I was surviving a sentence. You were a storm pretending to be a shelter. You called it passion, but it was punishment. I watered dead things. I stitched red flags into rose bouquets. You weren't a lesson. You were a warning, and I just refused to listen. So tell me this, was that love or was it self-destruction wrapped in longing? Don't lie to yourself. And the worst part, I loved you deeply, but not anymore, not anymore. That's it. Thank you.
Thank you. Ms. Fickbaum, are you sure that you don't have anything else to say? All right, thank you. Ms. Bauer, is that all of the statements?
Yes, Your Honor. I'm a point actually. Christy Matson is a friend and she wants to speak.
Any objection? A close friend?
Well, did she submit a statement to the Department of Corrections in the PSI process?
I don't know.
No,
I don't recall who all did.
he did not.
She did not.
I don't have any objections.
Mr. Winquist, any objections? No. Okay. You may provide a statement.
I didn't catch the name. I'm sorry, Judge.
Krista Matson.
KRISTAMATTSON.
All right, you may begin.
I'm here on behalf of Christina Fickbaum. She is actually not very much able to speak for herself. And the one statement that I would like to leave the court with more than anything is that she is asking for the highest amount of sentencing that can be provided under what he has already said guilty to. And that is it.
All right. Is that all, Ms. Bauer?
Yes, Your Honor.
Okay, I'm now going to turn to the attorneys for arguments. Mr. Schmidt.
Thank. Sorry,
I do have cough drops up here if you would like.
I'm good. I just swallowed wrong right at the part where I need to speak. As the court recalls, the state is free to argue in the sentence, except that the second-degree reckless with the dangerous weapon will be concurrent to the felon in possession of firearm associated with the firearm used in it. And that will be consecutive to the felon in possession of firearm charges associated with the guns in the closet, which will be concurrent with each other. That means the state is therefore capped at 12.5 years initial confinement and 5 years extended supervision on the first cluster, and 5 years initial confinement, 5 years extended supervision on the second. Totals about a 27.5-year sentence of imprisonment, which is comparable to what DOC recommended, which was a range of between 11.5 in and 18.5 in, aggregating all their consecutive counts, and 6 to 7 out, aggregating all their ESs that they recommended. The state's recommendation.
I think that's incorrect. That's not how I added up what the DOC's recommendation was. I believe for count one, it was 5.5 to 6.5 in. And then 2 to 3 for all other counts, consecutive, all consecutive.
Yes, I added them up, and that's what I added up to if you run them all consecutive. Unless if I read that wrong.
They're all consecutive, okay, consisting of, oh, they did 1 to 2 initial, that's right, okay. I wrote down 2 to 3 and it's 1 to 2.
Yeah.
Judge, my understanding is the Department of Corrections recommended essentially 16.5 years.
Well, they gave a range is the thing, so I was including the range.
If you go to the maximum range, it's 16.5 years.
Oh, well, regardless, my recommendation is going to be the upper end of what I'm capped at. It's going to be 17.5 in and 10 out. which is relatively close to what DOC recommended. In Wisconsin, for any case, for any sentence, the court must always consider probation first. It must consider something called the McCleary-Gallion factors, which is the gravity of the offense, the character of the offender, and the need to protect the public. When we actually argue this in practice, we usually break down those more abstract legal terms, those three, into more specific things like deterrence, punishment, incapacitation, rehabilitation. Those subcategories of those factors are easier to break apart and discuss and apply facts to than something general and big like protection of the public. Those factors and sub-factors, I believe, can be generally split into two categories. Factors are supposed to be predictive of behavior, related to the character of the offender and the need to protect the public. Those are things like specific deterrence, rehabilitation, incapacitation. Those are all things that the judge has to largely look at the facts and predict what's going to happen in the future. What is the lowest sentence that will specifically deter this offender from doing this again? What is the sentence that will rehabilitate this offender in the future so it won't happen again? If it's not possible to fashion a sentence that could accomplish those things, do we simply incapacitate the offender with a long sentence? That's what I mean by predictive factors. The other factors have to do with largely what we might call accountability or more broadly public policy. These are punishment, general deterrence, and not depreciating the seriousness of the offense. These are factors that have less to do with the defendant as an individual and more to do with the nature of the offense and its relation to the community. The public needs to know how different behaviors will be generally deterred from other people who would do them in the future. They need to know that offenses involving particularly bad morals or bad mens rea or bad impact to the victim will have that cause higher social and victim costs, will have higher penalties to satisfy the general social and psychological need for punishment, and to not depreciate the seriousness of the offense by doing something that would offend and depreciate. In both those regards, this case is largely fact specific. So I'm going to quickly overview the facts of this case as it relates to that. This is a case where Michael Winquist shot Christina Fickbaum in the head with a shotgun, not outside, not during like a hunting incident or cleaning a weapon, but for no reason at all. It was done in the kitchen and there was no danger there. There was no home invader. There was nothing like that. In the days leading up to the offense, there were no indications that this was something that was predictable that was going to happen. Analysis of the phones of both of them showed the relationship was good. According to the child, according to the child who was there in the home, there was no argument in the immediate lead up to it. There was an argument earlier in the day in which they were arguing about money related to the child's father owing them money and a need to possibly engage in civil suit for that. What happened is at some point in the day, Michael Winquist, who had not been sleeping for days, had been drinking constantly for days, was on what you might call a bender, suddenly was heard by the child who was in the basement, suddenly wake up, crashing around in the bedroom, stumbled to the kitchen. He heard a gunshot. His first thought was, well, Michael Winquist often will like shoot like squirrels and varmint and things like that, until he heard a body drop. And then he went up and found the image of Michael Winquist in front of his mom with a gun with her bloody on the floor. He fled, and when he was outside, he had to watch Michael Winquist shoot himself. He wasn't sure if Winquist was dead or not. Later on, he would go back in and remove the firearm. Michael Winquist was there ineffectually doing some sort of care to the head wound while mumbling something about dreaming. The victim, Christina Fickbaum, miraculously survived. She survived a gunshot wound to the head. In fact, she walked herself out of the building to EMS outside. The injury that she really was inflicted with wouldn't become apparent until later. In fact, if you watched her right after the incident in the hospital, you wouldn't detect any sort of impairment in how she's interacting at all. none of the cognitive or neurological issues that you've heard from the victim statements today. That was an injury that has worsened and festered and grown and gets worse with time after the injury was inflicted, the initial gunshot. At that point, law enforcement asked her the question, what happened? And she couldn't remember for obvious reasons. She was shot in the head. They asked her, do you have any idea why this happened? And she couldn't give an explanation. The person who had been living with him didn't know. The best she could do was speculate it's associated with his PTSD and him fighting in his dreams. But she didn't know the answer. In the PSI, she was interviewed by the PSI writer, as well as many family members and other people who just know Michael Winquist, where it was discussed that he's violent. He engages what one might call domestic violence, offering another possible explanation for what might have happened. Nobody really knows, though, because of the lack of memory, what actually caused this. I'm going to come back to that later. Michael Winquist at the time was on probation. He was on probation for felony OWI. He was prohibited by the conditions of probation from consuming, possessing alcohol, absolute sobriety. He was prohibited by the law, because of the felony nature of the conviction, from possessing firearms. In the PSI, he specifically talks about that shotgun in the closet. Why do I have it? It's for the purpose of protection. That is not allowable for someone who is a felon. You can't just keep it for protection, or else the prohibition would mean nothing. Everyone could just have a firearm then, and everyone knows that. It wasn't practical to think you could actually do that. As alluded to, as time passed, the injuries worsened. I don't think I can do a better way of summarizing the effect on Ms. Fickbohm that has already been explained by the victim, by her family, by the people who've observed her day in, day out over time. That wasn't conveyed by her describing herself as feeling like she's becoming a burden on the people around her, that her existence has transformed since then. She's living a different life than before the injury. She's been inflicted with devastating physical, mental, emotional, neurological injury. And they're an injury that worsens with time. It doesn't get better. I think what the court can gather from that is that this is a victim that cannot and will not ever be made whole, either through anything the court can order, through any restitution that Mr. Winquist could do, because the way she's going to experience life from now on is forever changed. This is, as far as I can tell, the worst injury, the worst impact on a victim I've ever seen in a case short of death. Because you also have those collateral consequences described too. She was really depending on the income that Michael Winquist gets to help try to save the house. She was really depending on she wants to be that mother that she was before to her child. It's apparent in everything she does and says. He wants her to be the mother she always was, and she's got these diminished capacities now. Even just the hearing loss can be a communication barrier for them, and that's devastating. So how am I applying these facts to my argument? This is where I'm going to start with what I call those accountability factors, because those are really fact-driven. Gravity of offense, protection of the public. So right off the bat, the need to punish and to not depreciate the seriousness of the offense is apparent. Probation has to be struck out right off the bat, even if not for the devastating nature of the injury and for the nature of the action and the danger of it, for the mere fact that he was already on probation when this happened. It would be perverse to do probation when someone commits an even worse offense while on probation. That's always a non-starter. I think it's apparent it can't be a jail sentence. It needs to be a prison sentence. It needs to be a long sentence. I thought it very significant in the pre-sentence investigation report that Michael Winquist himself said he should be sent to prison for double digits. He recommended over a decade of imprisonment himself. That itself conveys how well it is known that for the need of punishment in this case, for not depreciating the seriousness of the offense, we're talking about more than a decade of prison. It is absolutely necessary. Because this is a case where, as Christina Fickbaum described it, she talked about lifelong injury. I'd imagine it more as and I think she used this terminology in the PSI, that she feels like she's going to be a prisoner in her body for the rest of her life. The state's recommendation, 17.5 years initial confinement, 10 years extended supervision. That's not going to be the rest of Mr. Winquist's life. He'll get out almost at age 50 if the court follows that recommendation. It is more than half his life that he's lived so far. It is more than the adult life he's lived so far, but it's still less than what Christina Fickbaum is going to be facing going forward, because we know the nature of her injury. It's degenerative. It's treatable, but not curable, if that makes sense for the court, if it understands that terminology. The sentence needs to be commensurate with that injury. Proportionality demands significant punishment. I'd also like to point out that the public, as I said before, these are accountability and public policy factors. The public must be generally deterred from similar conduct to this in the future. The public needs to know, to avoid the sense of outrage that would be caused by depreciation of the seriousness of the offense, that behavior like this, that has an impact like this, use of a shotgun in a house against someone in the head, in the kitchen, this needs to be met with a massive punishment. Something less than that would, by offending the morals of the community, would affect public safety, would affect feelings of community safety and public safety. That's really what these factors relate to. Protection of the public also relates to the feelings of public safety. This is where I'm going to transition into what I call the predictive factors related to the character of the offender and protection of the public. Talk about specific deterrence, rehabilitation, incapacitation. There's a reason I outlined the facts and the conflicting information about what the cause of it was, and the fact that even, let's look at the PTSD, the sleep fighting, the domestic violence, the alcohol use. None of these is still a great explanation for why it happened. These are all negative factors that could contribute to something, but there's no explanation. What is the explicit thing that happened to cause him to get up, grab a shotgun, go to the kitchen, and shoot Christina Fickbaum in the head? I've alluded to in the past hearings, that was the main thing police were trying to figure out. We were trying to find a motive. We were trying to find sense in something that was utterly senseless. And it turns out it was a folly. And that's exactly why I think these factors do not bode well for Mr. Winquist. This was not a violent action in regards to a hot argument. This was not, what we call a hot homicide where, hey, the child in the basement heard them having a loud argument and fighting and then escalating. This wasn't that. So we can't say it was that. Could have been any of the things I described. With the PTSD, what's even the source of the PTSD? He served in the military, but he served in a non-combatant role. Could it be the shooting that happened that was alluded to by the victim advocate? Well, Mr. Winquist was simply standing outside a bar. He was shot in the buttocks by a scope rifle for really no reason at all. He did nothing to deserve it. He did nothing to call for it. Imagine the impact on you that it would have. Just stand.
An accident.
He has no idea of doing that. I'm explaining from his perspective. He's just standing in public and all of a sudden shot with a rifle. Like the impact on him in terms of PTSD on that. Could that have been the cause? Is it the alcohol? Was he in a drunken sleep, deprived of that, going through a PTS dream? Was this just an expansion of domestic violence that kept rising over time? A cold action that had a cold heat, if we're talking about American literature, with no planning and no end game. Was this related to stress from inability to pay the mortgage on time and the bank's actions to start foreclosure on it? Nobody has the answers to these questions. not me, not the victim, not Mr. Winquist. Because of that, it puts us in a very precarious position when we're talking about the predictive factors. When we're talking about what sentence can the court do that will specifically deter this offender? What sentence can the court do that will effectuate rehabilitation of this offender? The PSI, the compass, says he comes back low risk. He shot somebody in the head and he comes back low risk. And that's not because DOC did something wrong. It's not because their risk assessment tools don't work. It's because we know the things that are predictive of future behavior, and they didn't predict this for this offender. Nobody predicted this was going to happen with this offender. And that's a problem. That's a problem because it makes it extremely difficult for the court to figure out what the sentence should be that would be the lowest amount necessary to specifically deter this offender. Can the court say, based on everything it has now, that 5 years or 10 years or 15? Can the court say, what is the thing that's going to rehabilitate him? With the alcohol, there's numerous references to it really just utterly ruining his life for his whole life, from starting young to getting busted down a rank in the military, to the OWIs, making him lose his right to bear arms, to this offense. As he was intoxicated, there's the blood results. It's a factor. We just don't know to the extent of how much. He's lost so much in his life to alcohol, and yet even while on probation for an alcohol-related offense, it's not deterring his behavior. It's not changing it. It's unworkable. When we look at the PTSD, there's multiple sources of it. He's aware of it. It's happening even in the description of Ms. Fickbaum about the sleeping, about the fighting in the sleep. What's he doing about it? It's something that's continuing. It's something that's worsening. It's something that's impacting the child that lives in the home, Ms. Fickbaum's child. He's been aware of the impact of the negative things on his life and not done anything to fix it. And especially with the alcoholism, we've seen a long history of inability to fix the problems on his own, in the community, through his own actions, even when it's impacting others negatively, especially when it's impacting himself negatively. That being said, there is something the court can specifically deter, something that I think everybody agrees happened and it shouldn't have. Two things, really. The alcohol I described, the thing that hasn't changed to no avail over a long period of time, but the possession of the firearm. I understand that most of the guns are Ms. Fickbaum's. They were the ones in the basement. However, he used those firearms, and the firearm kept in the closet for protection that he himself said that is the purpose for why it's there. That's just disregard of law. That's just wanton disregard of law, especially allowing those things to be present when you are going through a period where you're just not sleeping, you're having psychological issues, when you are just on a long bender, when you're not making good decisions. The reason for the felon in possession of firearm laws is because people who get convicted of certain serious crimes, we've made the determination that they simply do not have the judgment necessary to safely have these weapons. That judgment's already been made. By law, Michael Winquist does not have the judgment appropriate for a person to possess and use firearms. Yet he's still doing it. He's demonstrating why he doesn't. It's impossible to look at this case and not think, if only he had been following the rules of probation not to drink, if only he had been following the law, none of this would have happened. I think that's really where I felt the most sense of outrage, especially from the victim when I've talked with her in our consultations. And because how could you not feel that way? I think everyone would feel that way in that situation. Because of the lack of success over time, over the military helping him with the overcoming the alcoholism, with the supervision on the OWI-4, overcoming that, with the lack of success, I think that the court needs treatment in a confined setting. That's one of the things the court has to consider. I think we've conclusively demonstrated for the things that could be rehabilitated on him, the mental health as it relates to the PTSD, the alcohol use, the sleep things, and even the domestic violence. These are all things that need to be treated in a confined setting, and that goes towards the sentence. But the real reason why I'm talking so much about there's not a good explanation for his behavior is because that is the sort of thing we look at when thinking about incapacitation. The reason I'm recommending a 17.5-year initial confinement sentence, even though Compass and the Department of Corrections says this is a low risk offender, is because the community needs to be protected from him. Nobody saw this coming. If you asked the day before this of Christina or her child, is she going to get shot tomorrow? None of them would have even fathomed they would have been anywhere near that. Michael Winquist's behavior is not predictable. It's like trying to predict a wild animal, whether or not it's going to strike or not. And that's the real danger, and why incapacitation, to me, overrides even specific deterrence and rehabilitation in this case. Because Christina needs time to heal. She needs time to feel safe. That's going to take a while. So does her family. The community needs to be protected from this, because there are multiple things that need to be addressed, multiple things that are going to take years. A 20-year alcohol problem does not get solved overnight. PTSD does not get solved overnight. These dream walking things do not get solved overnight, and domestic violence does not get solved overnight. Addressing these 4 things in a confined setting will take a long time, and the mere fact that we still can't say any one of these things was the cause means the court needs to be thinking about incapacitation over specific deterrence and over rehabilitative needs. I would add that, given the nature of this offense, specific deterrence itself still does weigh in a large prison sentence. We need to specifically deter this offender from firearms and alcohol when those were 2 of the biggest driving factors to him shooting somebody in the head. In sum, the McCleary-Gallion factors tell us that the court should do the maximum sentence on that reckless injury, that 12.5 years initial confinement, 5 years extended supervision. It's hard to imagine a worse way to commit that offense than this. I can't think of one. I'd be surprised if the court could. On that grouping of felon in possession of firearms in the closet, the court should do the max of that as well. It is hard to imagine a worse version of felon in possession of firearm offense for an offender other than the offender shooting somebody while possessing firearms in their home. From a fact perspective, it merits a significant response. There is no obvious path to rehabilitation for the risk that this offender poses to society because of the myriad problems he has. He's known for a long time these issues make him dangerous, and he's ignored that despite legal and professional consequences. The firearms in the closet should be concurrent to each other because they're mostly Ms. Fickbaum's weapons. They were stored in the same place. It's Ms. Fickbaum's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those 2 things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17.5 in, 10 out, with max on the reckless, max on the felon possession of firearm, those concurrent to each other, and then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
Thank you. Mr. Harrington.
Thank you, Judge. Before I analyze pursuant to the McCleary factors, I want to add a little more context the circumstance. And in the course of adding to the context, I must make reference to Ms. Fickball. I want the court, I want Mr. Schmidt, Ms. Fickball, and all of her friends here to understand that I am not in any way blaming Ms. Fickball. She was the victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. Mr. Schmidt suggested that the circumstances of that day were not predictable. They were not predictable that day. But the facts, the background and the facts made this tragedy absolutely predictable. First of all, let's look at the circumstances of Mr. Winquist and Miss Fickball. They were engaged in a presumably romantic relationship. Miss Fickball's statement emphasizes that in retrospect, it wasn't romantic, it was abusive. Mr. Winquist has told me that in fact, he considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring for many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm gonna still be in victims' rights compliance.
He needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take,
She doesn't want to hear this. Yeah, that's right.
okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you, Judge. He wore the wedding ring in jail for months. I can't tell the court when he took it off. He considered that they were married. They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the plea, or the PSI, he gave her $75,000 because he thought they were going to stay a couple. He needed expenses, the money to pay some expenses in the house. And they needed to make some repairs. They lived together. They shared the living expenses. They vacationed together. They enjoyed each other's company. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. The discovery reflected that when in the month before May 31st of 2024, there had been flirting by email between these two. But there's one other thing that they did together that made this tragedy predictable. Right? Right. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Fickball's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. We in the court system far too often observe the tragedies that result from increased alcohol consumption. As people continue in that process, they drink more and more. They make poor choices. They engage in riskier behavior. If they continue with that risky behavior, usually that consumption leads to a tragedy, both in their lives, but oftentimes in others' lives that are just innocent bystanders. My example is the instrument of the tragedy in most instances is an automobile. This instance, the instrument was not an automobile, but it was a firearm. A Remington 870 12-gauge shotgun. So I also contend and argue that in this particular instance, the tragedy was predictable because of the circumstance, but the tragedy was also predictable when we look at the instrument that was used. During the search of the house after the crime, law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there. They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. And that was Christina's handgun. They discovered in the basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded .22 Marlin rifle and a loaded .22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. But the date was May 31st, 2024. All those facts came to head, resulting in this tragedy. Michael Winquist and Christina Fickbone had consumed alcohol beverage during the afternoon, and I'm making these factual statements on the basis of the discovery. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. I don't remember where I found that, was in my notes. I rather suspect that I got that number from some electronic discovery that I received. They consumed the alcohol. They visited a neighbor. Christina was driving the motor vehicle. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. He is the victim of this horrendous tragedy, no doubt. As noted, there are three factors the court must consider in sentencing a defendant: gravity of the offense, the character and rehabilitative needs of the defendant, and the need to protect the public. Gravity of an offense or offenses is generally a comparison of what the crimes are, what's the maximum penalty, and other penalties that the legislature has determined are appropriate for a certain course of conduct, the maximum penalty. And then the other thing we look at is what happened. There isn't any question that these are serious offenses. The maximum penalty for count 1, second degree reckless injury, use of a firearm as a penalty enhancer, 12.5 years confinement with 5 years of extended supervision. Those are the maximum penalties. With respect to felony and possession of a firearm, the maximum penalties there are 10 years with 5 years of confinement and 5 years of extended supervision. Are not as serious penalty when you look at the public policy as determined by the legislature, but serious in any event. And they should, the count 2, second degree reckless, should be more serious because it is based upon reckless injury. Whereas counts 3, 2, 3, 6, 7, and 8, possession of firearm by a felon are really status offenses. Although one could certainly argue that 2 is not just a status offense. And I concur with Mr. Smith that it should be held together or bound together with the sentence as to count 1. Counts 3, 6, 7, and 8 are status offenses because people convicted of felonies, whether it be felony non-support, OWI felony, or any sort of a felony, shouldn't possess the firearm. The legislature has made that policy determination, and it's appropriate. Suffice it to say, this is a serious offense because of what happened to Christina Fickball. On the head, the shoulder, with after the shotgun was discharged, the impact on her life is profound and permanent. These are serious offenses. There is no argument about that. Character and rehabilitative needs of the defendant. Michael is now 31 years of age. He's a high school graduate. He honorably has been discharged from the United States Marine Corps. Some of the people interviewed by the Department of Corrections agent, one person in particular, and I don't remember who it was, and it doesn't matter, said that merely because he's a veteran, he isn't entitled to any break. Agree with that. Michael agrees with that. Michael agrees with that. Michael was a United States Marine, is a United States Marine. And Marines accept responsibility and adapt their life to accept that responsibility and serve their public. Michael received his first OWI when he was in the Marine Corps, and the PSI reflects that he accepted that responsibility. He lost pay, he lost rank, he worked hard, regained the rank, and eventually was discharged honorably from the United States Marine Corps. He was injured while on active duty, receives a 90% disability benefit from the Veterans Administration. He had been employed until he was the victim of the accidental shooting in 2021. He contributed to society. He contributed to the household. He was a substantial contributor towards the expenses of the household. As noted, Ms. Fickbohm provided care for him in his rehabilitation. During the healing from the gunshot wound he received, he had too much time on his hands and money. And if we look at the course of his life, he began consuming alcohol at 12. It became problematic at 15. His alcohol consumption probably declined during his Marine Corps service. But after he was shot, he had too much time and the alcohol spiraled out of control. He was convicted of OWI-4, and that did change his life because it doesn't appear that he was particularly driving on May 31st of 2024. Michael didn't have a father figure growing up. His relationship with his own father was strained. He only saw him sporadically. His mom was a single parent and was working, and Michael and his brother really had to take care of themselves, discipline themselves, and had brotherly disputes. People learn their parenting skills from the parents that they have. There was much discussion in the PSI about Michael's disciplining of children. Michael's using a stopwatch to make the kids eat in a specified time. Judge, having been a United States Marine myself 50 years ago, that's what drill instructors did. Was it right? Then it was. Is it an appropriate parenting strategy? No. But that's where we're at. And Michael. Mr. Schmidt mentioned the PTSD-like trauma or diagnosis. The evaluator for the NGI evaluation diagnosed him with a trauma and stressor-related disorder. It may qualify as a mental disease or defect, but not sufficient not to an extent to support the NGI defense. The evaluator opined that Michael Winquist may be appropriate candidate for mental health and/or substance abuse treatment. You know, that was an interesting opinion from the evaluator, but the court, Mr. Schmidt and I have all worked in this business for many years. And we didn't need an evaluation to tell us that when we look at all the facts here. Michael's not perfect. Made mistakes. He loved Christina Fickbohm. It was love. Michael does want the court to know that not everything said about him in the PSI is an accurate characterization. He is very much remorseful. The agent concluded that he had no remorse because sometimes Michael hesitated when he was answering questions. Victims, DOC agents, judges, prosecutors, Judges and prosecutors know this more than others. Clients are instructed by their lawyers to be very careful with what they say in jail to agents and others. When we started the PSI process, I told Michael to be truthful, not blurt out answers to the agent's questions, and to take his time. And Ms. Lineweber drew those conclusions, but that's the explanation for his hesitancy and that sort of thing. Michael's going to read a statement. Ms. Fickbohm and her advocate outlined that Michael has never apologized. And again, that's at my recommendation. Any statement a defendant makes while has jeopardy can be used against him either at trial or at sentencing. Does not make statements that can create more legal issues when you're facing these sort of circumstances. I mentioned that the characterization of Michael's relationship isn't entirely accurate. I mentioned that Michael wore the wedding ring. He has her name tattooed to his chest. He says that his name, at least one time, was tattooed to part of Christina's body. He gave her the $75,000 to pay her bills. He commingled his veteran benefit and paid a large share of the living expenses. He wasn't always employed, and he helped her, and she helped him. Specifically, he denies the characterization from his ex-wife. He tells me that was not, at the end, a pleasant experience for him or her. She, according to Michael, holds a great deal of acrimony to him. As the court can see from the PSI, the children went back and forth between Wisconsin and Oklahoma, sometimes by legal order, and sometimes by come and get these kids, I'm tired of them. And that's her saying that to him and him saying that to her. And then when most at the time of this incident, the children were living with her. Finally, Michael admits these crimes, stands ready to accept the court's punishment. Protection of the public. That is that third McCleary factor. And we all know what the case law says. It says that if appropriate, community supervision ought to be the first disposition. Does Michael Winquist need to be incarcerated for 30 to 35 years, as many think, to protect the public? No, he doesn't. Is his underlying personality and substance abuse dependency issues so severe as to preclude treatment within the community? No, it's not. Would not imposing a period of confinement unduly depreciate the gravity of this offense? And there isn't any question that the answer to that question is yes. The profound impact on Ms. Fickbohm, the use of a firearm, possession of a firearm as a felon, all those facts suggest that there needs to be confinement here. Just, it's appropriate now that I comment on a couple things that Mr. Schmidt said. And Mr. Winquist knew he had this post-traumatic stress type disorder. He knew he was an alcohol, consuming alcohol to excess, that he was an alcoholic, that he had substance abuse issues. He knew that he had bad dreams. He knew that the firearm was there. But we see people like that all the time. People that have substance abuse issues, they can't solve it in a day. It's not a logical question that they have in their mind. I'm a drunk. I'm going to go get cured, and it happens. That isn't what we see. General deterrence, in my opinion, doesn't work. If there's a severe sentence here, isn't going to change the fact that somebody else that drinks too much and that keeps loaded firearms in and about their house isn't going to have the same tragic circumstance. That isn't how general deterrence works. Specific deterrence, I agree with Mr. Smith. Specific deterrence deters this particular person from this particular behavior. So there does need to be a period of confinement to not depreciate the gravity of what happened here. Traumatic impact on the victim, continued consumption of alcohol, and the possession of a firearm. With that, how long should Mr. Winquist be confined? Department of Corrections, as to count one, Department of Corrections, with respect to all counts, did not recommend a maximum penalty as to any of them. That sort of surprised me a bit. But the Department of Corrections, the agents, the supervisors are familiar with all the law that we have, everything we've talked about, all the dynamics of substance abuse, mental health issues, and the range of penalties for these similar type crimes. As to count one, the Department of Corrections has recommended as a maximum in their range, 8.5 years, 6.5 years of confinement, 2 years of extended supervision. As to count two, the department recommended 3 years imprisonment, 2 years confinement, 1 year ES consecutive to count one. Then counts 3, 6, 7, and 8. The department continued with that 3 years as to each, 2 years confinement, 1 year ES, but all consecutive to each other. I agree with the Department of Corrections analysis, with the exception is counts 3, 6, 7, and 8 should be concurrent with each other, but consecutive to counts 1 and 2. That's the analysis of the Department of Revenue, Department of Corrections. There are status offenses. The firearms for counts 3, 6, 7, and 8 weren't in the bedroom. They were downstairs, in a closet, behind a dresser, loaded. They were loaded. At no time during the investigation of this were those firearms tested to see if Michael actually touched them. There weren't any fingerprint analysis. There was no DNA analysis on the firearms. If you look at the photographs of the firearms, there was rust all over those things. They hadn't been cleaned. They hadn't been properly preserved. So there should have been some effort to investigate and determine if Michael actually touched them after his OWI 4th conviction. That's why I emphasize that these are status offenses. They were in the house. They were available if he wrestled around for them. He's a convicted felon. They shouldn't have been there, but they were. That's the basis for those convictions as to counts 3, 6, 7, and 8. I urge the court to adopt the Department of Corrections recommendations, with the exception that counts 3, 6, 7, and 8 be consecutive to consecutive counts 1 and 2, but concurrent with each other. Judge, I started this conversation, this argument, with noting the tragedy, and it truly is a tragedy. Could it have been avoided? Yes, but it would have taken Michael to recognize his substance abuse, did not. And we're here, and that's what this is for. A final note, Michael paid the $10,000 initial payment on restitution a couple months ago. He tells me he sent another check for $2,582.23 to the court just within the last couple of days.
It
The
was
restitution
confirmed.
request has been paid.
It has been confirmed that that has been paid. So what is the total initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial confinement, 4 years ES.
All right.
Actually, 10 and a half years, Judge. I'm sorry.
Okay.
Real quick before Judge does her thing, I did tell you guys that I needed to be done at the 2-hour mark, but I'm not going to leave this hearing in the middle of it. So we'll go into a third hour long enough to finish this hearing.
Count 2 consecutive to count 1, counts 3, 6, 7, and 8 consecutive as to counts 1 and 2, but concurrent with each other. We believe that satisfies the needs and is appropriate. I have calculated his credit days through today at 565 days, including today. Thank you, Judge.
So 564 because you don't count today.
564. Yes.
All right. Mr. Winquist, I'm now going to turn to you and give you an opportunity. Actually, I'm going to wait to see if the victim would like to come back in. All right. The victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know. This is where you can state anything that you've heard that's been inaccurate, or you can go into more depth about things that have been argued or stated or that are in the facts in this case. This is where you have the ability to show any remorse or anything of that nature. You do not have to give a statement today, but it is your only opportunity. If you are going to read something, please read it slowly, enunciate your words, and please speak into the microphone.
Okay.
You may begin.
Thank you. I would like to make an apology.
Harrington, can you please move the microphone closer to him? Thank you.
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. I would also like to apologize to Donovan. you should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that I've had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
Is that all?
Yes, Your Honor.
Let me send this to the court reporter so she can dump time.
Yes. Would you like that filed as a document or just with the court reporter for record of the record?
You can file it as a document, Judge. Then,
Okay.
then it'll be there.
Then she has a copy, she'll get a copy, and then the court will have a copy. Okay, thank you. The court has reviewed the PSI multiple times. Multiple times. I've highlighted, I've taken notes. I've read this so that I could have a better understanding of you, Mr. Winquist, a better understanding of the victim and victims here, as well as a better understanding of what happened or what people believe happened that day. Your attorney has stated, and the the state has as well, the factors, the things that the court has to focus on when it comes to sentencing. Number one is the nature and the gravity of the offense. How serious is the case? Is this matter? I have to look at your character, your prior criminal record, anything, any rehabilitative needs or other things with you. I also have to look at the need to protect the public. And here it's twofold. It's the victims as the public, as well as the general public. Because I believe everybody can state that this is true, that alcohol and firearms is very serious, and it's a threat not only to the people in the near vicinity, but it could also pose a threat to people in the general public. That's why we have separate, firing a firearm while intoxicated and other crimes related. It's serious. The court also has to look at the effect on the victims. Again, your rehabilitative needs, any undesirable behavior patterns from you, your culpability, your age, your education, the history. And as Mr. Schmidt pointed on, as well as your attorney did, deterrence. There's two types of deterrence: general deterrence, to generally deter others from thinking about doing something similar. And there's specific deterrence, deterring you specifically from committing this crime and other crimes. I have heard and considered the arguments from both attorneys. I have heard your statement. I have read again the information contained in this pre-sentence investigation report. I have heard multiple victim impact statements. And it's a lot for the court to digest. You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with the domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. You pled guilty to that offense, and you have pled guilty to 5 other very serious offenses of possession of a firearm by a convicted felon. When the court first tallied what prison time was originally hanging over your head, I arrived at approximately 130 years if the court did a maximum possible penalty. Because if you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the dangerous use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless, with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety. It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is. But I don't rely heavily on the Compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your Compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head. So that's where the Compass really doesn't come into play, or I can't rely upon it heavily, especially because the Compass in other serious crimes, such as child sexual assaults or offenders or child pornography cases, those individuals also generally show a low risk. So I can't gauge based upon that. What I have to gauge upon and what I have to look closely on is your history, whether this is an aggravated incident, an offense, if there's aggravating factors. I have to look at your ability to rehabilitate, your ability to understand the seriousness of your actions, and not just your action in this incident. We all know that this is extremely serious. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not in any way, shape, or form ever touch a drop of alcohol. And I have to go to a statement made by your counsel as it relates to your operating while intoxicated fourth offense, fourth conviction, which is a felony. It was stated that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. You continued to engage in other activity that you were prohibited from while on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive, and it appears he wasn't driving the day of the incident. That's the only thing that it perhaps changed your life. Maybe you didn't drive that day, or we have no facts that suggest that you drove that day. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. So I don't think your OWI 4 conviction changed your life. If it had, perhaps we wouldn't even be here today. I do know that that day did change the victim's life. It changed her son's life. It changed her entire family's life. She now feels like she is a burden. She's not the same person she was previously. She feels she never will be. And I know that it was brought up in the PSI and was brought up in arguments here today that, and from the victim herself, that you were shot with a rifle during an incident. I remember that day, not that day, but I remember that incident very clearly because that impacted your OWI 3rd conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were and struck you in the buttocks. Accident. It was an accident. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other, any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It was not a heat of the moment type of incident. We don't have anything that from the juvenile who was there, who heard fighting all day, who heard a huge fight, and then all of a sudden a shot. He was downstairs in the basement playing a video game. He didn't hear that. You have had alcohol issues since you were 12. I know that it's been stated that that's when you started using alcohol and it didn't get bad until you were 15 and you didn't have a problem until 15. But I'm going to tell you, starting drinking alcohol at the age of 12 is bad. it shows an issue. And again, you nodded your head up and down. It is. That was the start of your downfall. And whether or not your consumption of alcohol decreased while in the Marines, which again is kind of hard to believe because of the stories I've heard of people in service. Even if it did, once you returned and you were honorably discharged from the Marines and you came back, that's when it started again, not from the date of when you got shot in the buttocks. Because again, I remember that because as I took your OWI 3rd conviction and I was being lenient to you in that conviction and was going to allow you to not have to sit in the jail for the 48 consecutive hours by law you're required to do, to serve that on an electronic monitor because of your injury. I took your conviction, you went up to jail to be processed, and you blew a .2 something. You were beyond legally drunk when I took your OWI 3rd conviction. So I had to redo that conviction to ensure that you remained sober. And no, I did not allow you to get out on monitor. That's where I found an error in the PSI. You had to sit in jail. I did not allow you to be released on monitor because that was serious as well. So your alcohol issue is what has gotten you here in part, because both sides have argued and stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have, serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. The fact that you were convicted of an OWI 4th offense of felony, you were told you were still on probation. You were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's not all on Miss Fickbaum's shoulders because that was her home. You are the one who knew exactly that you could not use or possess firearms. Yet you did. And the argument or the statement made was you had the shotgun to use for self-defense. That is not an excuse. That is not a reason to have an exception for a prohibition to firearms. There would be if your life at that moment, you needed that weapon for self-protection because it was imminent and you were in a life-threatening situation. You were not. And as applied to you with an OWI 4th conviction, still on probation, extreme alcohol misuse, and alcohol disorder. You had no judgment no judgment to even be around firearms. Alcohol and firearms are dangerous and can be very violent. So as applied to you, that prohibition is necessary. And then you add all in your personal issues, the violence, the aggressiveness, the PTSD, those nightmares. On top of that, especially as applied to you, the prohibition is necessary. I do have to look at your rehabilitative needs and to see if you have the ability to rehabilitate, if you want to rehabilitate, if you want to change your life. Because this, as it's been stated or argued, that this has impacted your life as well. It's kind of like a shot again to the victim that it's impacted your life. Your freedom may be restricted. You may be incarcerated for a significant period of time, but one day you will be released, even if it is on extended supervision, and you won't be suffering from the lifetime effects that the victim is. Not to mention her son. The trauma of having to hear the thud, knowing the thud when he came up was his mother, knowing she was shot in the head, not knowing if she was going to live, having the fear that you could have, in whatever state you were in that day, knowing, not knowing, shot him and killed him. How you've devastated his life and his relationship with his mother. She's not able to do activities or do things as much as she was before. He now feels like he has to protect her. He now feels like he has to be the one to care for her. He's a child. He is a child who does not deserve to have to worry about these things. And now he does for the rest of his life. I want to make sure that I have covered everything that I have highlighted. As I'm looking, I do want to point out that it's a miracle. And thankfully to all that believe in higher powers, it is a miracle that Ms. Fickbaum is alive. But what she suffers from daily is worse than death. I'm not going to even expand upon the statements made about the other domestic violence with your ex-wife or the things that I think are abuse, emotional abuse, and other things with your children, and the fact that you had them eat under a timer, because I don't have any real concrete information that either of that has occurred. Because you do state, and you have stated to the DOC agent, that you were never physically abusive to Ms. Fickbaum. You were never abusive. You were not a violent or abusive person. The PSI says that there is a lack of remorse, and I know that Ms. Fickbaum has stated that that is something that she has been missing as well, seeing a lack of remorse. Your attorney has stated that he has directed you not to speak about that. You did provide that here today in a statement saying that you are sorry for those actions and what happened. That shows some remorse. I'm not sure how much, but that shows some remorse. Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense and not wanting to unduly depreciate that gravity, and to find a term of incarceration to meet the court's objectives. The court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in alcohol consumption that day, and she may have been extremely intoxicated as well, she in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. With regards to count one, the second-degree reckless injury with the domestic abuse enhancer and the modifier of use of a dangerous weapon, the court is going to sentence you to 17 and a half years of initial confinement. That would be the 12 and a half years for the underlying second-degree reckless injury, plus the max for the use of a dangerous weapon modifier of 5 years. The court finds this to be so egregious, so serious, that the maximum possible penalty is necessary, not only to protect Ms. Fickbaum, but to protect the public in general, because I have not seen that you have a desire to follow the rules and to follow the law in any way, shape, or form.
Judge, I'm interrupting. I do that at risk. You said 17 and a half years confinement. I think the maximum is 17 and a half years imprisonment, 12 and a half confinement, 5 and
12 and a half okay, I read that on Mr. Schmidt's argument. So 12 and a half years, well, Mr. Schmidt, because it says the maximum, not more than 12 and a half years. Oh, 7 and a half is the maximum. Sorry. I apologize for that. So with count one, the court is going to sentence you for the underlying second-degree reckless injury, 7 and a half years of initial confinement. and then the maximum for the use of the dangerous weapon, totaling 12.5 years of initial confinement with 5 years of extended supervision. As it relates to count 2, possession of a firearm, convicted felon, the court also finds this egregious. The fact that he knew he was a convicted felon, as applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other. As to count 3, possession of a firearm by a convicted felon, the court finds that that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2. As to count 6, possession of a firearm by a convicted felon, the court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2. And concurrent with count 3. For count 7, possession of a firearm by a convicted felon, the court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2.
Judge, did you say consecutive or concurrent? 7 is concurrent with 6 or consecutive?
Consecutive. It's consecutive to all counts. Count 8, possession of a firearm by a convicted felon. Same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2. In my calculation, it's 26.5 years of initial confinement. And I believe 16 years of extended supervision. The court finds this to be so egregious, so serious, and so preventable. Had Mr. Winquist recognized his problems and did something about it, he did not. He failed to do anything, and he had sign after sign after sign, and he failed to even recognize or address them. And he continued to violate the law. He continued while on probation to violate the law and violate his conditions of probation multiple ways. An extended supervision when he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program. Until the last 3 years of his sentence, if any. On extended supervision, absolutely no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription, gainful or some type of employment to occupy his time and his mind. It does not have to be full-time. It can work with his disabilities. Absolutely no contact with Christina Fickbaum or any of her family members, any residents, any employment that she may have or her family members may have. The court is also going to order that he has an AODA assessment and follow-through treatment. He engages in some type of criminal thinking, such as thinking for a change or breaking barriers. The court is ordering $12,582.23 in restitution. The court is going to order $518 in court costs and fees per count, except for count 1 has an additional $100 due to the domestic abuse surcharge. These are felonies. Absolutely no use or possession of firearms for life. No voting in any election until your civil rights are restored. Court is ordering his DNA. This is not something he can have expunged due to the seriousness of the crime. Failing to pay his fines and fees, a civil judgment will be entered. If he is released on extended supervision and has not paid his fines and fees, a warrant will be issued. He can sit up to an additional 6 months in jail. Restitution is paid, so the court is going to order at minimum a monthly payment of $150 per month until paid off in full. The court ordered court costs, surcharges, and fines are to be collected as a percentage as determined by the Department of Corrections to be reasonable while he is in a state prison, and as a condition of extended supervision, he is ordered to pay those upon release. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe I've covered everything, Mr. Schmidt.
Just to clarify, I think I wrote down wrong about 3, 6, 7, and 8. The court ordered 3 and 3 out on all of them. They're all consecutive to counts 1 and 2. 3 of them are consecutive to each other. 1 of them is concurrent to that group, totaling 26 and a half and 19 out.
19 out. You could have added the ES correctly. I didn't write down the ES. I was trying to do it by my head.
Okay.
So,
Did I state the rest correctly?
correct.
Okay.
Anything else that is missing, Mr. Schmidt?
That wasn't missing. I think I just heard wrong.
Mr. Harrington?
No.
All right, then we are adjourned.